Good morning, everyone. It being 9 o'clock, we are going to begin the public hearings in criminal justice. I would ask that everyone rise and join me in a pledge of allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. And with that, I'm going to open the public hearing on, what's our first one? HB 1460.
1468 FM.
68, excuse me.
If I might. Thank you. The committee now calls Sue Hamola. Representative Hamola. Did I pronounce that right? Thank you. Oh, I just got, okay, you're not the prime. Very good. Representative Tony LaBranche to introduce the bill. Apologize for the confusion.
Sorry, that was my bad. Good morning, Criminal Justice and Public Safety Committee. I'm here on behalf of the prime sponsor to introduce this bill. I'm a co-sponsor. So I will first start off by explaining the bill. This simply removes cannabis from all current RSAs and therefore legalizing it. In talking with other representatives, I believe the prime sponsor and I have come to the conclusion that there's better bills than this one, especially the chairman's bill. So with that, I ask the committee to ITL this bill. Thank you.
Thank you very much, and we appreciate that, and so does the entire House. Thank you. Does anyone have any questions of the sponsor? Representative True.
Thank you, Mr. Chair. What bill do you think is better than legalized cannabis? Which bill?
So thank you for the question. I support legalization 100%, and I've been working with the chair on his bill. I can't remember the bill number off the top of my head, but it's Representative Abbas's bill.
Thank you.
For the record, that's House Bill 1598.
In addition, we also passed one on the House floor 2 weeks ago that fully legalized, I believe, as well. Thank you. The witnesses, excuse, thank you.
The committee now calls Representative Hamola. That's it.
Hi, thank you for hearing testimony today. I understand that one of the sponsors has just requested ITL, but I still would like to take about a few minutes to express some thoughts I have on this bill and on legalization in general. I was not able to attend the hearing on the 20th of January due to being out of town, so I appreciate you giving me just a few minutes today. I also want to apologize. Reading testimony is my least favorite form of presenting, but I'm operating off for about 3 hours of sleep right now, so I'm just gonna read to make sure I don't miss anything. I was initially to oppose HB 1468 and to provide overall comments regarding the legalization of cannabis. We are at the point where data is available from other states to evaluate how legalization has impacted their respective areas. While some perceive New Hampshire as lagging in legalization as compared to surrounding states, I view this as an opportunity to evaluate the effects of legalization and to avoid some of the most concerning unintended consequences. In places like Colorado and Washington, where legalization has been underway for some time, we can see how it's playing out. According to a variety of studies, to include a 2016 report by the Rocky Mountain High Intensity Drug Trafficking Area, which is an agency tasked with documenting the impact of legalization in Colorado, here are some of the results. Cannabis-related traffic deaths have increased by 48%. Youth marijuana use has increased by 20% in the 2 years following legalization. Cannabis-related emergency room visits nearly doubled 2 years after legalization. child welfare-related cases increased after legalization. There was a marked increase in babies being born with THC in their bloodstream, which primarily affected communities of color and low-income families. 5 years after cannabis sales began in Washington, the number of accidental ingestion of cannabis by young children essentially tripled. And across the United States, we can see the effects as well as far as child exposure to cannabis edibles. In 2016, those numbers were 187. In 2020, the number rose to 3,000 annually. In a survey by the Substance Abuse and Mental Health Administration, the results detected a significant increase in youth marijuana use in legalized states during a time when mental health indicators actually worsened. In our neighbor Vermont, the Southwestern Vermont healthcare system actually recently started reporting a rise in cannabis-related stomach disorders. This is due to the high THC levels contained in today's cannabis, which then gets stored in body fat and accumulates until the patient experiences severe abdominal pain, persistence, and sometimes uncontrollable vomiting for up to a week. One of the other examples that we have is Oklahoma. Oklahoma actually does not have legalized cannabis. Actually, Oklahoma it permits the use of growing and the use of medical marijuana. This is a little close to home for me because I moved here from Oklahoma. It was one of our last military assignments. I actually work as a hazard mitigation planner in my day job, and every day I talk to county emergency managers in Oklahoma. One of the things that's happened there is overwhelmingly these emergency managers are reporting the same issue. Oklahoma's cannabis laws have attracted a massive influx of organized crime into their rural areas. Some of the most rural areas now have a definitive presence of Russian, Chinese, and Mexican cartels operating farms under legal protections. Worse yet, many of these farms are repeatedly sold multiple times a year at top dollar. And most emergency managers recognize and understand that this is just a legal way for people to launder money, for these cartels then to launder money by continually selling the same farm over and over again to somebody else within their organization. This actually happened to Oklahoma overnight. It has been shocking to them. It's been shocking to the emergency personnel there at how fast the rural, quiet areas of Oklahoma have been upturned. There are many unintended consequences that accompany cannabis legalization. What is particularly concerning is that if any proposal that calls for legalization 18 years and above, there is still a well-documented and prolific information out there that demonstrates the negative effects of repeated cannabis use on brain function of young adults into their late 20s. And with that comes many negative mental health consequences to include long-term depression, increased suicidal ideation, and increased instances of mental health disorders. There's data out there. It's just fact. I know that there are individuals on both sides of the political aisle here in New Hampshire who think that legalization of cannabis should happen because it's already been legalized by our neighboring states. Part of the pro-legalization messaging promises that cannabis will reduce drug offenses, be a tool for social justice, reduce black market selling, and provide a more regulated and safer product for adult users. The fact is that we're already seeing the data coming out of other states. Not only is legalization not living up to any of its promises, states who have legalized it are seeing more unintended consequences that are putting the majority of their citizens at stake. One of the things that's not in testimony is that there is a gentleman named Robert Corey, and he's a lawyer in Colorado who actually played a pivotal role in the movement of legalizing marijuana there. He helped draft Amendment 64, which permitted the production and retail sales of recreational cannabis in 2012. He also designed and implemented their dispensary framework and for patients and caregivers under Amendment 20. He's a trial attorney. He's represented hundreds of clients accused of marijuana-related offenses, and he litigated cases and administrative actions involving Amendment 64's implementation. Yet nearly a decade after Colorado has implemented legalization, this is what a quote that he said in this past year. "I wish I could be proud of what we created, but I'm not. The outcome of 64 is shameful, hurts people, and Colorado is not safer. So I just want to leave us with this thought. If you think that New Hampshire should legalize cannabis to emulate its neighboring states, then we are not living up to our promise of being independent thinkers. If you think we should legalize because you feel it will happen sooner or later, then we're ceding control of the issue and ignoring the factual information that has emerged from other states. If we think we should legalize because some adults want to use cannabis, then we are forgetting that our greatest responsibility in life is to ensure the health and safety of our children before our own self-interest. And if you think that we should legalize cannabis just because it'll put a few more shekels in the general fund, then shame on us all. Thank you.
There being no questions, thank you for your testimony. Is there anyone else wishing to testify who didn't sign up? All right, at that point, then I will close the public hearing on HB 1468. And we will be at recess until 9:45. We don't. All right, at the having heard various positive sounds from the committee, I'm going to go ahead and open the executive session on HB 1468. And anyone wish to make a motion? Representative Conley. And is there a second? Seconded by Representative Pratt. Would you like to speak to your motion?
Mr. Vice Chairman, I believe the sponsor who spoke said it pretty clearly enough, so we can move on.
Very good. Anyone else wishing to speak? Representative True.
Thank you, Mr. Chair. In the past, I have said on the House floor, and I'll repeat that for anyone who missed it, I am a child of the 60s, and it was, in fact, 1973 before I found out the 60s were over. 1468, House Bill 1468 legalizes marijuana. I think that is a much better approach than other bills that have come to the floor or come through other committees. Many other bills earmark millions of dollars so that the state can have programs to help people who are abusing the drugs the state is selling. That does not make any sense to me at all. The state should not be involved with selling any more drugs than it already is. House Bill 1468, plain and simple. It's legal. Leave people alone. If they want to smoke it, fine. If they don't, fine. I can't support the ITL. Thank you, Mr. Chair.
Seeing no further comments, the matter will now be put to a vote. The Secretary will call the vote.
Vice Chairman Roy.
Yes.
Representative Lang.
Yes.
Representative Burt.
Yes.
Representative Rhodes.
Yes.
Representative Green.
Definitely yes.
Clerk votes yes. Representative Spillane.
Yes.
Representative True.
Sorry, no.
Representative Pratt.
Yes.
Representative Marston. Representative Harriet Gathright. Representative Panalakis.
Yes.
Representative Tulersky.
Yes.
Representative Bourdonnais.
Yes.
Representative Muse.
Yes.
Representative Ray Newman.
Yes.
Representative Bolden. Representative Conley,
Yes.
Representative Sue Newman,
Yes.
Representative Bradley, Chairman Abbas. Okay, the vote is 16 yeas, 1 nay.
Representative True, will there be a minority report?
Yes.
Anyone have any objection to consent?
3 not present.
Mr. Chair, I don't see any sense of it going on consent.
Just wanted to ask.
Was that?
Okay, now the House will, the committee will stand in recess till 9:45. Okay, it being 9:48, we're going to go ahead and start the public hearing on HB 1175 is now open.
The committee now calls Tony LaBranch.
Thank you. Good morning again, House Criminal Justice and Public Safety Committee. My name is Representative Tony LaBranch, and I represent the town of Amherst. I come before you today to introduce House Bill 1175, an act relative to recording interactions with public officials. This is a simple bill which adds a single sentence to RSA 570-A:2, which is New Hampshire's wiretapping and eavesdropping statute, which makes it a crime to record others without their express consent. Now, we can all agree that makes sense. No one should be recorded without their express consent, especially because in New Hampshire we have a constitutional right to privacy. The issue with the current statute is that similar statutes in other states have been ruled unconstitutional by multiple federal courts, including the First Circuit of Appeals in Boston. The issue with the current statute is that it does not make an exemption for recording public officials, which has been ruled a constitutional right in cases such as Glick v. Cunniff. This bill would add that exemption to statute and therefore make it constitutional, preventing the state and local governments from unnecessary lawsuits relating to constitutionality of the existing statute. This bill has broad tripartisan support and is a simple update to the existing statute to make it conform to the First Circuit's decision in Glick v. Cunniff. And with that, I ask that the committee pass this bill with an ought to pass motion, and I'm happy to answer any questions.
I have a question. So by public officials, please give us a definition of public official as far as the bill goes.
So my definition of a public official would be anybody who's employed by the state, state being any government in New Hampshire, because I believe it's a matter of transparency that we know what they're doing with our tax money, what they're doing on behalf of the people of New Hampshire, and I think that it should be our constitutional right to record them.
And if I allow myself a follow-up, is there any notice requirement in your bill? In other words, could a member of the public walk up to one of us on the street and secretly record a conversation without letting us know they were doing so?
In this bill specifically, thank you for the question, I'm simply just making an exemption in the wiretapping statute and not adding anything else in any other statute. It's just updating the wiretapping statute because I know one of my constituents was charged with this statute when they recorded their interaction with the police on their own property. They will speak to that incident in the next person speaking, but that is my understanding.
Representative Panalakis.
Excuse my voice, but are you saying that if I go in a grocery store and speak with one of my constituents about a bill or something that's going on, that they should be allowed to record it?
Thank you for the question. This is any employee of any government in New Hampshire should be allowed to be recorded in this bill. I believe they currently have that right to record representatives such as myself and yourself. But this bill does not say anything about giving notice. I believe that would have to be a separate bill. This just makes it not a Class B felony or a misdemeanor to do so.
Thank you.
Representative Burt.
Thank you, Mr. Chairman, and thank you for your testimony and your bill. I wish my name was on it. If I understand correctly, what the last speaker said, if you could answer yes or no on it, I think in public, we can record.
That is my understanding, yes.
All right. Follow up, Mr. Chairman?
Yes.
All right, thank you. And what this bill does is so I have my town clerk, my chief of police. If I go visit them during their work day, this bill will allow me to videotape them. Now, if I go to their house after their work day, the current law would still pertain and I couldn't videotape them at that point because they are off duty. Is that correct?
That is correct, and I will even go further and just read the simple sentence that we're adding to this RSA. It just says, a person adding the exception to the current wiretapping statute saying that a person to record a public official in public while the public official is in the process of performing his or her duties. So it is only when they are on the clock working for the state that they can be recorded in public.
And Mr. Chairman, one more last follow-up.
You may.
Thank you, Mr. Chairman. And I've talked to the ACLU about putting this bill in the past. I've talked to them about wiping out that provision because in Vermont, where I came from, we can record single consent. They keep saying that this is the way to keep it for personal use, but they do support, at that time, I was wondering if you know if they still support doing this particular bill.
Thank you for the question. It was my understanding that they do support this bill. I don't believe anybody is here to testify on their behalf, but it is my understanding that this is supported by them, yes.
All right, thank you.
Representative Muse.
Thank you. If the definition actually includes all employees, would it include, for example, someone like an active duty firefighter in the process of actually fighting a fire? My question is there are some employees in government whose duties involve things that are hazardous or dangerous, and having other people get in the way of those activities can actually put other people in danger. I'm just wondering if you could comment.
There would still be able to have a corridor around a crime scene or a fire. It would just mean that they could be recorded without fear of prosecution under the existing statute. We see, fires on the nightly news on WMUR, but the WMUR is not being charged for violating that wiretapping statute. So in that specific case, I believe that that right is already guaranteed, that they can record firefighters, police officers, and other public officials without being prosecuted for that.
Representative Spillane.
Thank you, Mr. Chair, and thank you to the member for taking my question. In the process of putting one of my bills together for this session, I had spoken with a lot of parents who've had interactions with DCYF, and I see this as a situation where this would be extremely useful if DCYF employees in the course of interviewing parents, whether in an attorney's office or not, could not refuse to be recorded. And currently the situation is that a lot of them are walking off and refusing to do the interview until there's no recording. And if it's not in an attorney's office, we run into potential complicated problems if the parent insists on recording. Would you say that this would solve that issue?
I'm not sure I understand the question.
DCYF is a public employee, and this would allow the parents being interviewed to legally record them in the process of their duties, which would be the interview with the parents, would it not?
In that specific circumstance, I believe that they are exercising their public duties and that anybody should be allowed to record them in the process of those duties.
Thank you.
Representative Gathright. Harry Gathright.
Thank you for taking my question. So you would consider yourself and all public officials or elected officials as part of this, correct?
Thank you for the question. Anybody that is employed by the state, and as representatives, we are considered employees of the state, so it would apply to anybody that receives a dime from any state or local government here in New Hampshire.
Thank you.
Representative Panalakis.
Thank you, Mr. Chairman. Thank you for taking my question, but you expressed that it would be when they were off duty, like a police or fire or us. I don't ever think there's a time that a police officer is off duty or a legislator is off duty. So how would we get around that?
Thank you for the question. To the point about police officers, you do punch out every day, and there is a time that you are off duty. Of course, an off-duty cop could intervene in a situation, and if they see it fit, if they're in a convenience store and it gets robbed, they could technically stop somebody. But in that case, they're usually in a public situation that's already being recorded by convenience store cameras. So I don't see anything wrong in that specific situation. And for legislators specifically, I believe we already, the people already have a right to record us at when we're in the public. That is the real important definition to see here, is that if we're shopping at Market Basket, or if we're doing our day-to-day duties, we're still being, we're in the public eye constantly, and they already have a constitutional right to record us.
Thank you.
Representative, sorry, I don't have see your
That's
name,
okay.
please.
Tolarski, thank you. According to how you just stated, anyone who is employed by the state, I assume then that it would extend to teachers on every aspect of their day, including bus duty in the classroom, coaching, extracurricular activities as advisor, even on field trip?
Thank you for the question. In my understanding of the bill, that could be a possibility. I hadn't thought about it, but that is definitely a possibility under this bill.
Representative Lang.
Sorry, that was the exact question I had. I was more concerned about a teacher in a classroom and students being recorded in the background and students being involved, and how would we deal with that in a teacher by this broad bill, which I agree with, but I also think there might be some unintended consequences. I'm trying to figure out how we would deal with that and what your opinion is of that.
Thank you for the question. It could be amended as to excluding schools, public schools, but I do not have any language that I would amend it to at the moment. That I would be more than happy to find language that would make that exemption.
There being no further questions, thank you for your testimony.
Thank you.
The committee now calls, looks like Lynn Osborne.
Anyone with a name even
Somebody
resembling
from
that?
Right to Know, New Hampshire.
Good morning. My name is Lori Ortolano. I live in Nashua. I'm Vice President for Right to Know New Hampshire, and Right to Know New Hampshire supports this bill, which would allow a person to record interactions with public officials in the furtherance of their duties. Installing video cameras in public buildings has become commonplace. As it stands now, per RSA 91A Section 2, anyone, just not local residents, must be permitted to attend a public meeting, and they can take notes, tape record, take photos, and videotape. The focus of my testimony is going to be in public buildings. Video recording employees performing public duties in public areas would allow the public access to information to determine if records are being handled correctly or if their treatment is equitable. It would permit a regular official to be memorialized through video. Our interpretation of public officials would include public employees and elected appointed officials. Our interpretation of video recording would include audio and video recording. The recording can only be done in public spaces with people operating in the furtherance of their official duties. Municipalities can video record, no audio, in public places without noticing the public, letting them know. I wondered if there's a legal obligation to inform a person if they're being videotaped in a public building, and if there's a statute that should be added to the document if that exists. I'm not certain it does, but that's one of my questions. In December, I just want to share with you a personal experience. Several years ago, I started investigating the assessing office in Nashua, and I just finished a trial in a right to know lawsuit that went to court against the city of Nashua. One of the claims was for video camera security footage that was created in the public customer service area of the assessing office. There were 3 specific times and dates I wanted. This video camera, upon investigating the office was set up the public service space with a whiteboard on the wall that would show you when the assessors signed in and out to go out and review properties. After I started questioning whether one of our assessors was actually performing those duties based on the whiteboard, the city removed the whiteboard from the wall. The very next day, they mounted a video camera in the ceiling to video record public people in this public space. In September of 2019, I made a series of requests for 3 pieces of film footage. I requested the recording because I believed I was being treated differently than other property owners coming into an assessing office. A clerk assisting me at the customer service counter with a verbal request to review property files was disciplined by management for helping me, and the employee was told, "We have you on film." The employee was then suspended for 2 days without pay for this. The requests were submitted starting in September 9th, and I didn't receive a response back from the city for over 2 months, November 13th, and the response was a denial. It took the city 2 months to deny, and the video, despite the fact that the city had a standing policy that no video would be released to the public. I learned about this in my trial. And yet, even though that was their standing policy, it took 2 months. The city denied the request by throwing outrageous...
Ma'am, if you could, I apologize for interrupting you. Could you stick to the substance of the bill? We don't want to talk about Nashua so much as we want this bill. Talk about the bill, substance of the bill.
Okay. Well, the substance of the bill is based on the fact that my request was denied, and I do, with all due respect, sir, I think it is relevant. I really do. I think this is very relevant. I've given testimony for 3 weeks up here, and you are the first person to say it wasn't relevant.
That notwithstanding, I am the chair, and I'm asking you to continue your testimony, but please limit it to the bill and not your experiences with the town of Nashua, at least the litigation part. You're free to tell us about how the bill would help you, but everything that happened after that is not relevant to the bill.
Okay. So I was denied based on 5 exemptions to see the video. Exemption for internal personnel practice. Exemption 91A5 for confidential and financial information. Exemption for personnel and other files whose disclosure would constitute an invasion of privacy. Exemption for records pertaining to the preparation for carrying out all emergency functions. And the Murray exemption for law enforcement compiling information. In summary judgment, the judge threw out 4 of those out of the 5. I'm waiting a ruling from the court. It was argued by my attorneys in December, and my position is if municipalities can mount cameras throughout public buildings and monitor our interactions with employees, use those interactions to video employees and citizens, use the video to discipline employees and reprimand the public, citizens should be able to video record our public officials performing their official duties. And on the record, I would like to say that when I spoke and said I was from Nashua, I observed the chair look over to my 2 representatives, and I believe obviously you have a bias about what I've done and you knew about me. Thank you very much. I won't take any questions.
The witness is excused.
The committee calls Rolf Vendeber.
Good morning, members of the Criminal Justice Committee. I'm here to speak in support of House Bill 1175, which adds public officials to the exemptions in the New Hampshire wiretapping statute. This bill is intended to conform to several rulings which conclude that it is a violation of the First Amendment to prosecute somebody for gathering information on an on-duty police officer specifically, but several other rulings in the First Circuit Court of Appeals have extended that to public officials. These rulings include Glick v. Cuniff, Martin v. Evans, and a more local one, Valentin v. City of Manchester. In 2019, I was charged with wiretapping as a Class B felony. I recorded an interaction I had with a police officer who was trying to enter my home and question me about a theft report in the area. At the time, I was 14 years old, and I refused to let the officer into my home or answer any questions. Thank you. A few weeks later, after uploading the video online so I can send it to my peers, I had my phone taken by my school resource officer without a warrant. I also had to forfeit my school laptop. Once a warrant was granted, the police department changed my school password. Having most of my assignments in a locked school account, this interrupted my digital schoolwork. My attorney had tried to dismiss the case as violation of my constitutional rights, saying that higher courts had already come to a conclusion on this matter, but the judge didn't take it. He said, and I quote, "It doesn't matter, this is a statutory court, not a constitutional court." And that's the line that ultimately convinced me to pursue this change. I reached a no prosecco with the department and performed 20 hours of community service. I spent that time volunteering with school board candidates, and the only real high school experience I had before the coronavirus pandemic was interrupted by a legal battle and mandatory community service hours, just because I had exercised my constitutional right to record a on-duty police officer. You might recall hearing about the similar arrest in March of 2015. Alfredo Valentin, a Manchester resident, was charged under the same statute for recording a police officer. In 2017, the city of Manchester paid him $275,000 to settle the lawsuit that he filed. I urge you to recommend to pass on this bill and to protect Granite Staters from unconstitutional wiretapping charges, especially as police accountability and general public official accountability has become an increasingly relevant topic in everyday life. And to the points about specifics with teachers and representatives and supermarkets and on the sidewalk, in the current language of the statute, it says that there has to be a reasonable expectation of privacy for this to be a charge. So say if you were at Walmart, Shaw's, on the sidewalk in a classroom, that wouldn't really apply, because I think that 30 high school students or a few Walmart customers wouldn't really have a reasonable expectation of privacy. That's not a very private environment. Thank you.
Representative Burr.
Thank you, Mr. Chairman, and thank you for your testimony. Would this bill help? Because I've seen some students get disciplined because there is a no videotape in policy in most schools. So would this bill help? Because I've seen when a student gets bullied, somebody else videotapes it and then it goes up online. Well, if it makes national news, everybody's okay with it. If it doesn't make national news, then the person being bullied is going to be in trouble. Would this bill help that, to stop, you know, some of the bullying going on in school, because then it's legal to videotape this? Or maybe it wouldn't, because it's not an employee of the state.
I'm under the impression that recording policies within their own district would be controlled by the district, but in the matter of the actual law, there wouldn't be a reasonable expectation of privacy there. And if there was only a few students there, then I don't think that the student should be charged with wiretapping or, disciplined by their school if they're recording a bullying incident, but that's a case-by-case scenario.
All right, thank you.
There being no further questions, I appreciate your testimony and thank you very much. You're excused. Is there anyone else wishing to testify? Please bring your pink card up.
The committee calls Ian Freeman.
Thank you. I am Ian Freeman. I am a talk show host. I host a talk program that's on 190 radio stations around the country. So freedom of speech, freedom of the press, pretty important to me. And New Hampshire has, for a very long time, been one of the worst states when it comes to the wiretapping laws here. I believe it's one of the 3 worst, in fact, as far as people in New Hampshire generally do not have the freedom to record a conversation to which they are a party without giving notice to all of the people who are involved. And this bill's not going to change that, per se, but it does do something very important, and it does allow people to record conversations with so-called public officials. My one concern with this bill, and I think it's a great bill, is as I read it, it says a person to record a public official in public while the public official is in the process of performing his or her duties. Having seen some of the prosecutions that people have been brought up on under this statute, I know that the courts, the police, they tend to interpret this as strictly as possible and in the favor of the state. So when I see the word in public, it makes me think about a friend of mine who called up a school official in the city of Manchester and recorded the conversation. Is a phone call with someone who's probably sitting in their private office, right, because you can't just walk in like you can walk into this room. They're a public official, they're doing their public duties, but are they in public when they're on a phone call with you? Well, this guy was charged with felony wiretapping as a result of simply recording a phone call where he had a few questions for this public official in the school system of Manchester. And he was found guilty of doing that. Now, ultimately, the state actually ended up mischarging him. They should have charged him with a misdemeanor because he was a party to that call. And so there's like a distinction between misdemeanor and felony. Anyway, he got charged for what should have been, in my opinion, an on-the-record call. So my concern with this bill is that it shouldn't say in public. It should simply be anyone who is a public official should be subject to being recorded at any time when they're doing their duties. So that's my one concern with this. Having listened to some of the questions up here, I don't think there should be a notice requirement in general to record anyone. And if you think about it, certain people who are, let's say, less than honest or not trustworthy, as some of the government workers can be, will change their behavior based on whether or not they know they're being recorded. So in other states, if you are wearing a hidden camera or a hidden audio recording device, you can go into a car shop that's been accused of doing dastardly things. They're doing repairs that aren't called for, or they're doing something that's untoward. And you can record them without their knowledge and see what they do. Maybe they're going to do something wrong. Maybe they're going to be dishonest. Whereas if you walk in with the video camera openly, they know you're recording, they're going to change their behavior. And so it's important to be able to record people without their knowledge, which is, again, this bill doesn't address that, but I'm explaining one of the big differences between New Hampshire and almost every other state. In every other state, as long as one person knows there's a recording, so if I'm the undercover recorder, I'm the person who knows there's a recording, it's legal. In New Hampshire, that's a crime. And so that means that we cannot hold public officials accountable. This changes that, at the very least for public officials. It still allows other private people to not be held accountable. So again, the statute still has serious problems even with this change. But I do support this change because if you've read the New Hampshire Constitution, you know that the Bill of Rights, Article 8 does specify that government here is supposed to be open and accountable. And if you cannot record a public official without their knowledge in the process of their duties, if they're on the up and up and they're doing the right thing, they should have nothing to be afraid of. So I support this bill, and I really appreciate your time. Happy to answer any questions.
I'm going to recognize myself for a question. What are your thoughts on the school part of it? We heard questions about regarding guidance counselors and things of this nature while they're talking to students and in the classrooms where minors might be picked up on the recordings, et cetera.
Yeah, I fully support the right of students to be able to record any interactions with any of the public officials at the schools. These people are paid by the state, and they should have no special rights, no more than anyone else. And it's certainly true that there are some teachers that are doing abusive things in their classrooms, that they're doing things that they shouldn't be doing, and I think that this could hold them accountable for that.
No, I guess the crux of my question is with regard to other students in the classroom being recorded who aren't public officials in the process of recording the public official in a classroom. What are your thoughts on that?
Run that by me one more time.
So if I'm a student and I want to record my math teacher because he's doing whatever.
Yeah.
I'm also going to be recording my classmates who are not public officials and who are minors and who have not signed a release to allow themselves to be recorded. What are your thoughts on that? Is there any way
I see
that-
what you're saying
Yeah.
there. In my opinion, if you are in a public place, you're subject to being recorded. If I go down to the park and I want to record what's going on in the park, it's my right to do that. Personally, I wouldn't because I think that's boring and it's not, something I'm interested in. But if you're in public, you don't have a right to privacy. And if you're in a public school classroom, you don't have a right to privacy. So if that's a concern for some kids, they shouldn't be going to government school and they should find a private school or go and be homeschooled where they'll probably get a better education anyway.
Representative Burt.
Thank you, Mr. Chairman, and thank you for your testimony. With the schools situation, I have some friends that are parents of high school kids, and they're always complaining about the TikToks that they're constantly recording in schools. And if I understand right, they're picking up kids in the background.
Sure.
In a public setting like that, you don't need consent, do you, from all the people around you?
The statute, as I'm familiar with it, and it is, a lengthy statute, is nebulous in general about what consent is. So I'm of the belief that if you're in a public place and you're obviously recording, if you continue to speak to me, you're consenting. However, I don't know if the courts would interpret it that way. That's just my belief as somebody who believes in freedom of speech. Like if we're having a conversation in a park and I pull a camera out, you should presume I am recording you. And if you keep talking, you should presume that that's going to be recorded. So in my mind, you're continuing to have that conversation is your consent to being recorded. But I don't know if that's ever really been addressed in the courts. And given the way the statute is written about all parties must consent, it's not all parties need to be noticed, if I recall. I don't have it in front of me at the moment. But the way it's written is not very good. And New Hampshire is one of the least free states when it comes to this.
Thank you.
Representative Bourdonnais.
Thank you, Mr. Chair. Thank you for taking my question.
Sure.
So if this bill becomes law, there would be no privileged space for public officials, and that's including courts of law, including grand juries, where we keep witnesses separated, their testimony separate from each other's until they have testified. And a recording of their testimony could be exposed to witnesses in the future to have influence on their testimony. Is that a concern?
Are you saying that grand juries are public officials, meaning that it's open to the public? Because my understanding, you cannot go into a grand jury. I cannot just walk in as a member of the media to record a grand jury hearing.
I'm uncertain of whether it's a public space, but
I'm telling you it's not.
Thank you.
Representative Conley.
Thank you, Mr. Chairman, and thank you to the witness for taking the question. New Hampshire is a state that values its freedom, undoubtedly. We are also a state that values individual privacy. The way this is written, I don't know what percentage, but vast swaths of our state, you could say half of our residents would qualify under this as a public person who could be recorded in their everyday duties, in their everyday life. I guess I'm wondering, does that concern you? Do we cede our right to limited privacy by virtue of running for a water board seat or getting a paycheck from the government?
I think you're overestimating the numbers of people that are considered public officials. This only addresses public officials. Those are people who are being paid, who have sworn some sort of an oath to perform a duty for the state. I don't think half of the people of New Hampshire qualify for that. It's probably less than a tenth would be my guess. But to answer your further question, yes. if you are a public official, if you have any kind of job where you're working for the state, you should be open and accountable, and that means that you should be able to be recorded in the process of your duties. That's part of the deal when you take this position, is people get to record you doing what you do.
It's not part of the current deal, but thank you.
That is the way it should be.
Representative Spillane.
And I'm sorry, just may I go on a little bit? You can be recorded right here, right now, without your consent. You can be recorded walking through the hallways without your consent. It's just the question is, should you be able to be recorded without knowing? And I think you should.
Representative Spillane.
Thank you, Mr. Chair. Thank you for taking my question. From your perspective, where does the reasonable expectation of privacy come in? Because a lot of the discussion I'm hearing, they're talking about recording people in essentially public places, which there is no reasonable expectation of privacy, and I would imagine that under current law they couldn't be charged anyway. For example, when videos are done of the protests in front of the State House, they don't get a waiver from every single person attending the protest.
That's right.
Because there's no reasonable expectation of privacy attending a protest in the front of the State House. For the same token, what you just said about walking down the hallway here, there's no reasonable expectation of privacy anywhere walking down a public room. There would be a reasonable expectation of privacy in one of the side offices, having a discussion with somebody one-on-one, but not in a hallway or in this room. So where exactly is the reasonable expectation of privacy and this law, or this bill that could become a law, intersecting? Can we kind of separate out what this is actually doing compared to what some of these other questions are that really don't apply because it's already got no reasonable expectation of privacy?
I see what you're saying. I think this bill would allow those conversations that you're talking about, whether it be with a DCYF official, police officer, or whoever it is that's having that conversation in a quote-unquote private room. They're still a public official doing their public duties. And that's why my concern is that there is this line of in public in this bill, which I think should be struck, because the courts are always interpreting this as strictly as possible. And if you're a public duty, I don't care if you're in your office or if you're on a phone call, you are getting paid by the state and you should be held accountable for that. So this would increase the ability to record government people wherever they happen to be.
Follow up.
Thank you, Mr. Chair. I agree with you about the public statement, because when I read that, that might become a problem if parents allow DCYF into their home and they record the interaction. Their home is obviously not public.
That's right.
Question.
So would you think that this bill would be sufficient enough as is with the removal of the word public?
I think it's an excellent improvement if you were to, I think it's fine as is, but it would be even better removing that word in public, those two words from this bill. I think it would be absolutely fantastic for accountability of government.
Representative Newman.
You can't see the Dean of the House. She has her hand up. I'll defer to the Dean of the House and then ask my question later.
Okay, Representative Panalakis.
Thank you, Mr. Chairman. I seem to think, thank you for taking my question,
Sure.
but I seem to think that listening to you, that you are saying that when you take a job or run for an office in the state of New Hampshire, you lose your freedom of speech.
No, ma'am, that's not what I'm saying at all. I'm saying you lose any kind of ability to have, or you should lose your ability to be private as a public official, meaning that you should be free to say whatever you want. I should be free to record you saying whatever you want as a public official. Does that make sense?
No.
What part's
but
confusing?
I understand you.
Okay.
Thank you.
Representative Newman.
Thank you. And thank you for taking my question.
Sure.
Just listening to the testimony, there's a lot of confusion about definitions. There's a lot of confusion about exemptions. There was testimony earlier that listed a list of exemptions. And that's just the way that these laws are written and presented when they're heard in the public hearing. So I'm having a lot of trouble with definitions of public official. I mean, you have one, we all have different ones.
Sure.
And I suspect that there are definitions in other parts of the law. So just for my question, we assume the bill is written that says in public space, public places. Do you think that in this building there are spaces that, other than the men's and ladies' rooms, that are private spaces where the public does not have access to those spaces and should not expect the ability to record things in those spaces in a public building that are, do you just agree with that concept? Are there or are there not? You may say there are none of them.
Yeah, I don't think this bill pretends to actually give people access to locked off areas or something like that. So I, as a member of the media, can't all of a sudden go into your whatever private area you might have with other state reps that I don't even know probably exists. But if I did know it existed, if the door is locked and it's authorized only or something like that. So this doesn't open up closed public or closed spaces, as I understand it.
And forgive me, the definition of public spaces and private spaces in public buildings is probably defined somewhere in the law. And
maybe.
I hope we get to look that up before we exec it. But so my other question is, like the school, we talked about schools. And the public cannot just walk into a school and walk down the corridor and walk into a classroom when the school is in session.
That's right.
So I wonder if you would find that to be a public space as it is in this bill. Or when you think we should be recorded, probably everywhere, but that's okay. Do you think there are spaces like that the public work areas, there are a lot of places that the public cannot just walk into. So I don't know if you agree with that definition or not.
Yeah, I see where you're coming from. And again, I don't think this bill addresses what is and what is not a public space. I don't think it opens any previously restricted spaces. There are obviously places that are government places, whether it be a jail or a school or whatever, where you have to pass some sort of rigorous examination in order to get into that place. If you are into that place, if you have been authorized to go into that place, I think that you should be able to record anything that goes on in that facility, whether you be a student, a visiting teacher, or whoever you happen to be.
Thank you very much for that question, for that answer.
I have what I hope is a simple question. If I'm sitting at a restaurant with my child, and they ask me, Dad, what's going on in the State House, and I sit and have a conversation between me and my child to educate them on what's going on, should I be able to be recorded by doing that?
By your child, you mean?
By anybody. Should somebody be able to walk up and stick a camera in my face while I'm just having a dinner conversation with my child? Is that because I'm a public official, I give up that right to have a free conversation with my child?
You're in a private business at that point, and I think that the business owner would be the one who gets to decide whether or not people get to record in their property. As a member of the media, I am uncomfortable. I generally decline recording when I'm in private businesses, unless there's something absolutely outrageous that, like if somebody gets attacked, right? Like then, okay, I'm going to pull out a camera and record that. But just, the normal procedure of business, I'm not interested in recording that without the permission of the business owner typically, because I do respect the idea of private places. So I guess that would come down to the question of, is a private business considered a public space? I would say it isn't, even though you could argue that it's open to the public. And again, that would come down to where, if anywhere, is this defined, the idea of a public space. Is a private business considered a public space under the law? I'm not sure. I don't consider it to be a public space personally.
Representative Rhodes.
Thank you, Mr. Chairman. Thank you for taking my question. So I do recognize that your back is up pretty straight on this, and you're taking a really, really firm stance. My question is more of unintended consequences. So you made this statement that most government officials are crooked.
I didn't say that.
You did.
No, he said some.
Untrustworthy. Okay. So I also would have to say that a lot of regular citizens are untrustworthy. We have a huge human trafficking, child pornography. It's a problem. It's a big problem. So I know in most schools, every parent has to sign a release, even if there's a parade, before they can put a picture of any child, even on their website, any kind of social media. There has to be a release signed. So are you saying that if somebody wants to go into the school and record all these innocent children that are sitting there have the right to be recorded because their parents are choosing to send them to that school?
If there are people in that school, their fellow students, who want to record, then yes, they should be able to record their fellow friends and classmates in public. That's what I'm saying. And if you want privacy, it's fine. I'm going to continue my answer. If you want privacy, ma'am, you are responsible for that. So you need to close your blinds. You need to stay inside your home and never leave, because every time you leave your home, you are being recorded, likely. There are cameras everywhere, whether it's you or your children or whatever, whether it's walking into Walmart or the airport or just driving down the roads. There's a good chance there are cameras pointed in your direction. That is the society that we live in. So if that's concerning to you, put on a mask, put on a hoodie.
Point of order.
Okay,
let's
that's,
keep it.
the witness will suspend.
That's fine.
There being no further questions, the witness is excused. There being no one else wishing to speak,
Okay, thank
the
you.
public hearing on this bill is closed. At this time, we will open the public hearing on HB 1571.
The committee calls Representative Dennis Thompson.
Thank you, Mr. Chairman and members of the committee, for hearing me this morning. I'm presenting this bill for its prime sponsor, Representative Tim Egan. He's unable to be here today. He has business in another part of the state. I'm not sure how many questions I can answer for you, but I'd be happy to try. He's given me a statement that he'd like read. HB 1571, relative to increasing fines for littering and directing revenues to the Fish and Game Department, is a bill that's important to protecting our environment, supporting our valuable tourism economy, fortifying our conservation officers, staffing, and supporting our under-resourced Fish and Game Department. I think we can all agree that enforcing fines has a value. An increase in fines means we're taking matters very seriously. The threat of fines helps visitors want to keep the roads and parks pristine. By forcing folks to keep our highways, byways, and attractions clean, it safeguards our tourism economy. We need to support the funding for the Fish and Game officers who catch poachers, monitor hunters, save lost hikers, pride themselves on studying New Hampshire flora and fauna, and support is shown in the percentage of the fine that's going to help to hire new COs, conservation officers. How does the harsh littering fines benefit our society and save New Hampshire residents money? It improves community feeling and economic impact. People want to populate attractions, but they want to populate clean attractions. A cleaner community draws tourists and their tourism dollars. A fine is a deterrent to those who can easily devolve, from littering or illegal dumping. And litter pickup by the New Hampshire DOT is labor intensive and costs a tremendous amount of money to the state taxpayers. I want to thank you for considering this bill, and I believe it'll have a tremendous impact. Take any questions.
Representative Burke.
Thank you, Mr. Chairman, and thank you for your testimony. If you know, because I definitely don't, do you know how much money is collected each year in New Hampshire from litter and fines, and then where is that money going right now? So, you know, if we're taking 20% here, we're going to steal it from somewheres. So what is being removed?
I don't know. I
Okay.
assume that the majority of the money goes to the highway department, because they're the ones that have to deal with that. What Representative Egan is asking for is that 20% of any fines, that they be increased, and that 20% of those fines be diverted to the Fish and Game, for training and for acquiring new officers. You may or may not know that Fish and Game is very tight on how many personnel they currently have in the field, and we need to find a way to fund that. This is not the only way, but it's one way that would help.
Yep, thank you.
Representative Bourdonnais.
Thank you, Mr. Chairman. Thank you for taking my question. I have a problem with the way this bill is worded. It says it will increase the fine for violations of this section by 20%. Most times when we look at fines, they're expressed as monetary amounts rather than an increase. Is that a problem?
It just so happens that I also sit on Transportation and Public Works and Highways, and yesterday we had a bill which proposes to increase the fines for littering dramatically over what they were. I think a first offense, a violation, was $64.50 initially, and the new bill would raise that to $300 for a first offense and $500 for a second offense. So it'd add 20% to those, which would create a substantial amount of money for Fish and Game. Also for the state, wherever that money goes. I don't know if it goes to the judiciary or if it goes to Public Works and Highways, but 20% of it would be diverted through a fund under RSA 206-35. And that really is what I can tell you. That bill is still in committee, and I can't tell you whether it'll pass or not, but currently I can tell you that first offense is $64.50, the second offense is $129, I believe. And if I might add something else, I'm from Coas District 1, and the biggest problem we have with littering in Coas District 1 is in our trail systems. And the reason it's such an intense problem is because the people who own those lands and allow the people to recreate on them, I had one stop at my office, one couple. They had walked one day when the OHRVs were on there, and they came out with 2 5-gallon buckets of beer bottles. I don't know how we can stop all that, but if we can make the fines so relevant to people's personal economy, that I think that's going to help.
So, if we were to make this a
Follow-up.
yes, thank you. If we were to make this a monetary fine, what would the fine you suggest?
Well, it's 20% of whatever the fine
I'm
is.
sorry, I in law, at 20%, I don't think that means anything to me.
Well, in a $500 fine, it would be
Is that what you would like
be
to change it
$600
to?
at that point, plus penalty assessment.
Okay, thank you.
There be no further questions. Thank you for your testimony.
Thank you very much.
The committee now calls Richard Head from New Hampshire Judicial Branch.
Morning, Mr. Chairman. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. We have no position on the policy of this bill. There were 2 things I wanted to briefly discuss. One is something it's also in your in the electronic filing of testimony, relates to the effective date. One of the things I'm doing this session is sort of going to every bill that has an issue relative to the effective date of bills, because it's important to the judicial branch. So I did want to take just a minute to briefly explain why it is that we are doing this and what the concern is. And what I've handed out is the letter of testimony, and then on the backside of that is the proposed amendment on the effective date. And this relates to a statute, which is RSA 14:9A, which talks about, which is a statute that actually defines when an effective date of a bill should apply, or what it should be. And what it says is that each law that affects judicial practice and procedure or establishes or eliminates criminal prohibitions, civil causes of actions or remedies, or limitations of actions shall take effect on January 1 of the following year. And the reason for that is, and I can use this bill as an example, this bill in several different sections of the statutes would have a modification to the fine schedules and would require the judicial branch to distribute those monies differently than we currently do. So what that means is that when a clerk is receiving money at a courthouse, that money has to be inputted into our system in a particular way so that this specific line of statute is also has a corresponding line in our Odyssey database, and that the Odyssey database has a code that tells our financial people 20% of this fine has to go to in a particular location. That takes time. So this bill impacts 3 different statutory provisions. Those 3 provisions have to be updated. And there are statutes or bills after bills after bills that do the exact same thing. They change felony provisions, they change civil provisions, and it just takes us time to get all those lined up. So that's the reason behind this statute. It's a long explanation, but I like to explain it to big committees because all of you are also proposing bills, and I do ask if you are proposing a bill that does any of these things, if you could make it January 1, you won't have to hear from me so often. So I try to give you an incentive to do that also. So I do ask, and I've proposed the amendment on the backside of what I handed out today, simply changing, if this bill were to go forward, simply change the effective date to January 1 of 2023. And then I would also be happy to answer any questions. I did do at least the judicial branch's fiscal note on this. I'd be happy to answer any questions if you had any regarding the fiscal note. And with that, that's all I had.
Representative Conley.
Thank you, Mr. Chairman. Thank you, Mr. Head, for taking the question. Can you clarify where fish and game, or where littering fines currently go in our state?
Sure.
Thank you.
So in what I have are the 3 statutory sections that are specifically referenced in this bill. So RSA 265:102, that goes to the highway fund. RSA 163B goes to the general fund, and RSA 163B3s, both the 163Bs, those are both general fund distributions. And what this would do under the new bill, or under the proposed bill, would be an additional amount that would go to the new fund that's created through the bill. The same amount of money would be distributed to the highway fund or the general fund, because it's only the additional 20% that gets sent to the new fund. At least that's how we read the statute or the bill. In addition, there is on all fines a penalty assessment, and that penalty assessment is distributed separately through a different statutory provision. And the split on penalty assessment funds are general fund, victim assistance fund, and the judicial branch's IT fund is the breakup. And the percentages on those, and I don't have the exact percentages of those of the penalty assessment distributions, but those are the 3 ways it gets distributed.
Representative Spillane.
Thank you, Mr. Chair. Thank you, Mr. Head, for taking my question. Over here.
Right, there we go. It's hard to hear, but I got these things, and then I got to find
Yeah,
somebody.
I understand. Can you tell me if dumping on private or public land and or industrial dumping falls under the same category as littering? because it seems to me that a better direction for money for fish and game would be those high-impact areas of illegally dumping large quantities of materials on those back dirt roads and field trails and such that actually impact those of us who go out hunting, and I think are more easily tracked down to the owner who dumped in a lot of cases because there's some identifiable information that's been dumped there, rather than littering on the side of the road where previously we heard about the person who brought in 2 things full of beer bottles. Unless you catch them in the act, you can't get that money. So I'm wondering if that's considered still littering, or if there's a different statute that deals with illegal dumping on private land, public land, and then businesses who do so.
Short answer is I don't know. Slightly longer answer is not based on my experience in the judicial branch, my experience in private practice. I think you might also implicate some of the solid waste or hazardous waste statutes in the Department of Environmental Services, depending on what the material is and the quantity, but you may have some environmental statutes that deal with solid waste or hazardous materials that would apply in a larger dumping situation. You also have some that relate to tires and other things.
Thank you.
Representative True.
Thank you, Mr. Chair, and thank you, sir, for taking my question.
Thank you.
Just look around.
I do a
You'll
quick
find,
scan.
You'll find the voice sooner or later.
I got to look for the little red light.
Let's see, where was I going? I don't recall you here last year with this. Maybe you were and I wasn't paying attention. Is this a new find that the dates, is that a new push for your office?
Yes and no. So I started about a year ago. Howie Zibble had the position before me. I don't know what Howie was doing. Unfortunately, last year when I started, I was doing everything remotely because at the time those hearings were all being remote. I did try to do it as much as I could. Last session, this session, I'm probably a little bit more active in the effort, only because we do see it a lot. It does have actually a substantial impact on the individuals who are trying to do all this. We see it especially in the criminal penalty sections, which has a whole area of recording requirements. So, for example, if any modification to a criminal statute, you're implicating the J1 system, the uniform charge table, which the Department of Safety and the Department of Justice have to line up so that when a law enforcement officer is filing a charge, that charge corresponds to the current version of the statutory provision and then corresponds to the proper penalties. And anytime you make a tweak in a statute, J1 has to get changed, the uniform charge table has to be changed, and then within the department or within the judicial branch, our Odyssey database has to be changed so that when that is received, our database has identified it with the current language of the statute as it's been modified in the legislative session and the appropriate penalty, whether it be a violation, misdemeanor, or a felony. And because there are so many, even the slightest modifications that occur, all of those lines have to be accurately reflected in both what law enforcement sees under the uniform charge table and then what the judicial branch sees in our Odyssey database to ensure that there are no errors at the time a charging document is filed with us.
Follow up? Thank you, Mr. Chair, and thank you. I was pre-med, not pre-law, but I understand why you need that extra time. In the past, if you didn't have that extra time, what happens? Say if this bill went through and nobody caught that is effective in 60 days, what would happen?
So I don't know based on personal experience. I don't know if mistakes were being made and documents had to be modified once something got filed, or if money was being sent to the wrong location for a period of time. I don't know the answer to that, but it certainly increases the likelihood of errors being made if those systems aren't up to date.
Thank you very much.
Thank you for the question.
Representative Panalakis.
Thank you, Mr. Chairman. Would you have any idea, Mr. Head, of how much money we take in per year?
So there are two areas in which the money can come in. So I only have the judicial branches. Some of it is paid directly to the agency. So we took 2020 data, and in 2020, actually we took essentially from November 1, 2020 through October 31, 2021. So when I put the note together, the total collected under the three funds was a little over $9,000. So the additional 20%, if you just take that, would be at about an additional $1,800 based on what we collected. And then I think at least the fiscal note that combines both our fiscal note and the Department of Safety's suggests that the total additional revenue would be less than $5,000 per year.
Thank you very much.
There being no further questions, thank you for your testimony.
Thank you.
Is there anyone else wishing to testify who hasn't signed up on this bill? Seeing none, I will hereby close the public hearing on HB 1571 FN, and the committee will stand in recess until 11:15.
It's cold in there.
It being 11:15, we will now be opening the public hearing on HB 1108 relative to the prescribed manner for posting public land.
The committee now calls Ellen Reed.
Thank you, Mr. Chair, and thank you, honorable members, for welcoming me to your committee. For the record, my name is Ellen Reed. I represent Rockingham 17, Newmarket, and Newfields. This short bill before you, all it does is provide an alternative method of posting one's land for property owners. It does not provide an incentive or disincentivize posting. It just provides an alternative method. It doesn't remove the current method. Now, why would we need this? Well, the current law prescribes the method of posting as putting a sign with lettering that's a certain number of inches tall, 2 inches tall, says that the landowner's personal information, contact information must be on the sign, and it has to be every 100 yards. But there's a few problems with this method of posting, and this is something that many other states, which I'll get into in a moment, have identified. Mainly that signs are not rugged when it comes to weather, when it comes to animals, when it comes to even people possibly tampering with signs. Signs typically only last a couple years. Also, they tend to be more expensive and more difficult to put up on trees. And they damage, because of the nail holes, damage valuable butt logs, which are the most valuable logs when you're lumbering, damage that lumber. So the easier, cheaper, faster method, especially if the landowner happens to be elderly or disabled and has a problem getting up and hammering signs into trees, the easier method is simply to spray a vertical line of paint. This is something that some 20 other states have already done. A handful of states have current open legislation on, and so that is what this bill does. It mimics the language that is pretty much uniform across the country. And just so you know, the states that have adopted this are typically big landowner rights states like Texas, Louisiana, Kansas, Idaho, Florida, Pennsylvania, Tennessee. Montana passed this in 1973, and Arkansas has been doing this since 1989. So it's a well understood, non-problematic way of posting land. So there are a few questions or concerns that I've heard when discussing this bill with interested parties. In general, most landowners seem very favorable to this, but I want to address the questions that I've heard. So the first question is, does this have the potential to cause confusion in terms of the idea that there's trail markings out there that might look like this? There are no standardized systems of trail markings that involve vertical paint stripes, purple paint stripes. Usually, and you may know this from hiking in our state parks, trail markers usually involve specific shapes and specific colors, not just a vertical paint stripe, usually on signage. Also, the question has been raised as to whether or not this could impact people who are colorblind, and would they be able to see the markings. Red-green color blindness means that if, in the worst example, you would not be able to distinguish purple from blue. Certainly, if you are colorblind, you know that purple and blue look the same to you, and this would be obviously a painted mark on a tree that looked like what you know as purple. Or blue, which are the same to you. So this is a very obvious, it doesn't look, for a colorblind person, a stripe of purple does not look like the tree, it doesn't look like the bark, it looks like a painted stripe of blue, which is very obvious to that person. In addition, I would argue that frequently, not always, but frequently people who are out there, and hunting is the most frequent example of someone who might be out there looking for no trespassing signs, that frequently they're not alone. So certainly they can confirm with someone else that they are with, but I digress. Another argument I've heard, or an idea I've heard, is, well, what happens when the property is sold and the new landowner doesn't necessarily want to post their land? Much like currently, if that is the case, the new landowner would have to remove the current signage that exists, which means getting up, pulling nails out of trees that now have been damaged, that now they own, might have wanted to sell for lumber, but those butt logs have been damaged by those nails. That's labor intensive. whereas covering up the purple stripe with brown paint is a much easier, cheaper, faster way to remove those no trespassing markings than pulling down those signs. And also, in either case, that can be made a condition of sale. They can ask that the current owner remove those signs by painting over them before they take over ownership. So the personally identifiable information, and I want to point out something that the lawyer did that I actually didn't request, but I know why he did it. In paragraph 1, it has changed the writing of the name and address of the owner or leasee is optional. Now, the reason that I know why he did this is because we've had a number of court cases where people who have trespassed on land argued that the signage did not include information of the landowner and therefore was invalid and they had a right to be on that land. And in every case, the judge has ruled that it is the intent of the landowner that matters, not whether or not they obeyed the actual letter of the law. So in court law, it's basically deactivated the section that requires the personal identifiable information. Certainly we can all imagine, most of us, I would say, probably don't want to put our personal contact information billboard style out in the open so that anybody could see it. So many landowners don't. In fact, I was just walking property with someone who I know is one of the best outdoors people that I've ever met. And we used the the posted yellow signs to find the boundary of the property that we were on. And those posted yellow signs did not contain personal identifiable information or contact information of the landowner. Now, another issue is, well, what if somebody's out there and needs to contact the landowner? What if there's an emergency, or what if the police need to contact the landowner? In every single one of those cases, well, I would say almost every single one of those cases, the easier way to find out that contact information is to look online on the tax map, certainly for municipal police who are probably very familiar with their town's website. The tax maps are updated relatively soon after a sale, whereas signs can stay up for a couple of years after a sale. And certainly the new landowner may not switch out those signs just because that information is no longer their contact information. They'll say, it's posted, that's all I care about. So if you're out in the wilderness, and I remember walking with my friend, it took us a few minutes to find those signs, to go the 100 yards, look through the woods, and find those yellow signs. So it might take you several minutes, especially if you're in the dark, to go find a sign, hope that there is personal contact information on that sign. Whereas you can simply go straight to the website and find out who owns that particular piece of land. Also, there has been an argument about, well, what is to prevent some rabid anti-hunting activists from going around just painting trees? To which I say, if there's a rabid anti-hunting activist or any kind of activist who wants land posted for whatever reason, they would already be posting signs up. That certainly if you're a rabid anti-hunting activist, a couple nails is not going to deter you from putting up signs when that's what you want to do. I will point out that it's illegal, whether it's signage or paint. It's illegal, and I will point to line 16, line 15 and 16, any person found removing, defacing, yada yada, the property of another. It's not just prohibited, it's actually a criminal penalty, Class B misdemeanor. But having said that, they would already be doing that. Do you know, and this is rhetorical, how many cases we have of people actually, like actual recorded cases of people posting signs on land that isn't theirs? There's no recorded case. However, we do have cases of people tampering with landowner signs to try to cover up the fact that they were on that property when they weren't supposed to be. And I guess that brings me to the main point, which is in case law, as well as I think just our reasonable understanding of what property owners' rights should be, the situation we do not want is people trespassing onto land that they know that they are not welcome, land that has been bought and purchased, many times because people want privacy, by people who don't want people on their land, And we don't want people trespassing on that because of a technicality. Because, oh, this sign didn't have the correct information, or this sign was not far enough away, or it fell down in a storm, or a squirrel ate it, or what have you. But that's the situation we don't want. That actually leads to conflict, which is why we've had court cases on this matter, and why the judges have repeatedly ruled that it's the intent, the clear intent of the landowner that matters. So with that, I'm happy to answer questions.
I have a quick question. The cases you cited, have those gone to the New Hampshire Supreme Court, or are those circuit court cases?
I don't believe any of them have gone to the Supreme Court and have been appealed to the Supreme Court.
Representative Burt.
Thank you, Mr. Chairman, and thank you for your question, or your testimony. I guess I'm concerned about some rabid, as you called them, four-wheeler, because my father-in-law owns a camp or a house in Colebrook, and there's a lot of them up there that want to stop all the four-wheelers noise and snowmobile noise. But luckily they haven't won yet. Hopefully they won't. But what would stop them from just going over, painting all the trails the purple? I know it's against the law, but you know, people break the laws every day.
Right, and that's why, I mean, it's why we have laws, right, to prohibit, not prohibit, but discourage certain activities, and we do have a criminal penalty for this. So yes, this is already illegal, but my point still stands, whether it's hunting, whether it's ATVs, what have you, that if it's somebody who's rabidly, you know, supporting a certain position, if they're willing to break the law, then they're certainly willing to go and put a nail up. So if you're not seeing those people putting those signs up, then there's no effective difference between them doing that and painting.
A follow-up? Thank you. Well, I somewhat disagree, because currently, if you put a posted sign up, it has the landowner's name and number on it. A spray paint would be a lot easier, and how, you know, then people would be, oh, that's trespass. You know, I can't trespass on that property. Where if the posted sign's just up there with no name, you know, people are going to question that.
Thank you again for the clarification, but as I said, Representative, that this has already gone to court, and the courts have repeatedly ruled that actually they don't need a personal contact information on that sign. If the intent of the landowner is clear, if that sign says no trespassing, then people are to abide by that.
And one last follow-up? Yep, thank you. Would you be objected if we change the fine from a Class B misdemeanor? Because I just see in my eyes of this being an issue of people spray painting purple everywhere, so that wish not to see these four-wheelers and snowmobiles, to like a felony charge.
I personally, for the purposes of this bill, don't necessarily have a problem with it. I would like to point out that lines 15 and 16 already exist in our current law. This is not something I've added in this bill. The only thing that's been added is the word paint marks to be inclusive of this new alternative method of posting. So this is something that we've already settled is what we consider to be a Class B misdemeanor, but if this committee decided that defacing somebody's property or posting on somebody's land that it wasn't their right to post on is something that is felony level, or maybe you might want to go to Class A first before you get to felony. That's certainly, that doesn't touch the intent of my bill, so I'm, as far as this bill is concerned, without weighing in on like what should and shouldn't be a felony, that I would be fine with that. But
right,
again, that would be up the purview of this committee.
Thank you.
Representative Green.
Thank you, Mr. Chair. Thank you for taking my question. How would this bill distinguish between a landowner that would allow people to walk his land, or possibly allow people to use a snowmobile or an ATV, but not allow hunting?
Thank you for that question. It's a good question. And the thing is this does not remove the current method. The current method specifically states, and it gives an example of no hunting or trespassing, states that you can prohibit certain activities without prohibiting all trespassers. So if you want to be granular and say, I'm fine with certain activities on my land, but I don't want these other activities, you can still use the current method and put those signs up saying no ATVs, or ATVs okay, no hunting, or hunting okay, no whatever. You can already do that, and you would still be able to do that with this. What this does is just allow a very easy, safe, quick way for people, especially people who currently find it very difficult to go around the perimeter of their likely wooded and rocky land, who may find it physically difficult, to put a more durable way to post everything up, which is not to say that they won't allow people on their land. Just as you all know currently, you can post no trespassing and then give particular people the right to be on your land to hunt. You can invite your friends over to a party. Just because you have no trespassing doesn't mean people can't come. It means they need your verbal permission. So all of that can still happen. This just provides an alternative for people to express their already existent property owner rights.
There being no further questions, thank you for your testimony.
Thank you so much.
The committee now calls Linda Dion.
Good morning, committee members. Thank you for allowing me to speak. I don't have a whole lot, but I was just going to say I'm a landowner. I don't have a whole lot of land, but I have woods behind me. And there's trails out there, there's a wetland, but I don't post. And part of the reason I don't post is because I don't want to put my name and address out there for everyone to see. So it's a privacy reason. I also don't like the idea of putting signs in the woods that pollute. And I'm a little bit of an environmentalist also. And these signs, you probably think they're paper, but they're not. They're made of a synthetic material. And the second page of my testimony talks about what the signs are made of. They are plastic. They will be there for a long, long time. They do not decompose. And animals, everyone knows that animals are like small children. They see something in the woods and they like to put it in their mouth. And so it's, I don't know if you just saw that turtle that swallowed the ribbon on the news and had to have surgery. That's what animals do. They see something and they like to ingest it. So it's dangerous. These signs are dangerous for the wildlife out there. And I guess that's about it. That's the reason I don't post. I would put paint on my trees, but these signs are not good for the environment. And that's all I have.
Thank you for your testimony.
The committee now calls Christina Snyder.
Good afternoon. Thank you for having me. I'm actually in support of this bill very strongly. The thing is, property owners, landowners, we have the right to post our property. We have the right to post against trespass. However, the onus of hardship is incredible for the landowner. What we have to do on our property every year is we have to go around the perimeter. We have to check for these signs. Yes, they get ripped off, they get ripped down. The animals do chew on them. Every year we have to pay for the signs. We actually, because they get ripped down so easily, we lug a ladder through the woods, climb up this ladder, and put nails into our trees. And nails are not good for trees. So now we have the choice. Do we harm our trees just to exercise our right to post our property? It shouldn't be that difficult. And I want to emphasize that New Hampshire Fish and Game strongly, strongly suggests that hunters contact the landowner before they hunt. No, it's not required, but they strongly urge that because there has been increasing issues with hunters littering, putting up illegal tree stands, and issues like that. And with this purple paint, it just makes it easier. Now, if I didn't have a partner, you know, I'm 5'1", I weigh 106 pounds. Am I supposed to lug a ladder through the woods to exercise my rights to post my property? Why is it that difficult? It shouldn't be that difficult. And here's the thing, even if your land is painted with these purple stripes, since Fish and Game says, please contact the landowner, it's fine that some of these people that might have it posted might have a friend or a cousin or a brother or an uncle and say, it's okay if you hunt on my land. Thank you for asking. Thank you for coming to me. And thank you for giving me some of your harvest. And then that way they have written permission and that person can still hunt on that property. It just makes it so that not every random hunter or every random person comes through. It gives the landowner discretion with their property and what they do with it. It shouldn't be that difficult. When we have to go through and we see these signs ripped off or shot at, it's just becoming completely a hardship on the landowner. And as far as with the colorblind, you know, I sent in testimony and I sent in some quotes from several sources. There's a little bit of confusion on that because some say that purple is actually one of the colors that's easier for colorblind people to see. I don't know. However, there is also that 8% of males are colorblind. So now if you have, say, very generous 100,000 hunters, 8%, so you have 8,000 hunters, and that's generous, and they're colorblind. So now the hundreds of thousands of people that own property, you know, our rights are not easy. We can't exercise those rights because we have to worry about a few thousand hunters that can't ask their buddy and say, hey, I'm scouting out this property. I see this paint on this tree. Hey, can you tell me what color that is? It's that simple. You know, when I see all of these discussions against this, it's just frustrating as property owners because I also know several people, some elderly people, you know, my parents, they wanted to post their property. No way is my 80-year-old father going to get up on a ladder, you know? So I have to go and help him and do that. It just shouldn't be that difficult. This isn't going to stop hunting. It's just going to make it easier for the landowner. And, you know, that's pretty much all I have to say. So I will take any questions.
Representative Muse. Thanks for taking my question. When you say getting up on the ladder, you get up on a ladder to post a sign because you're trying to put the sign out of reach of somebody who could easily tear it down. Is that the rationale?
Yes, previous we would just go with my partner and he would reach up as far as he could and then he'd tack into the tree with the nails, destroying the tree, which we took the chance and we did. And what we found was, yeah, they were easier because anybody could just go through and it's easier for them to just be pulled down. And we did find that when we lugged the ladder through the woods and put the signs up higher, it's a little more difficult for them to get ripped down and destroyed that way.
Thank you.
Thank you for your testimony. The committee now calls Patrick Hackley, New Hampshire Division of Forest and Lands.
And just before the witness begins, just to the members of the committee, if you look in your drawers in the committee office, there's an updated book for all of us to I strongly recommend you bring with you. You can leave it in your drawer. Everyone should have one.
All set? All right. Good afternoon, Chairman Abbas and members of the committee. For the record, my name is Patrick Hackley. I'm the Director for the Division of Forest and Lands and also called the State Forester. I just want to thank you for the opportunity to testify on HB 1108. The Department of Natural and Cultural Resources, Division of Forests and Lands, does not take a position on this bill, but I'd like to offer the following comments. The Division of Forests and Lands is the state agency charged with the execution of all matters pertaining to forestry, forest management, and forest lands within the jurisdiction of the state.
one of the division's key responsibilities is to enforce the state timber harvesting laws, including cases of timber trespass, where boundaries are a very critical part of that enforcement, and also to manage forest fire protection programs and activities in cooperation with local municipalities. The Division of Forest Lands, we manage about 170,000 acres of state land. We also manage about 60,000 acres of land for the New Hampshire Fish and Game Department and 13,000 acres of land for the Army Corps of Engineers and the flood control areas of the state. I've also been a forester for about 35 years. So this bill as proposed raises several concerns for us. Purple boundary paint to indicate no trespassing is a completely uncommon practice in the Northeast and is not widely recognized by the majority of landowners, foresters, surveyors, and forest recreationists. Posted signs are well recognized and can be easily added or removed as the landowner desires or ownerships change, as opposed to essentially permanent paint marking. I've listened intently to the previous speakers, and I understand the frustration and concern, but consulting with a forester to advise them on how to attach these signs to a tree would be worth their while. You can use a half-inch or quarter-inch galvanized nail and just tap that into the tree. You don't even have to tap it in completely to hold a very light vinyl sign. So the nailing does not destroy the tree necessarily, and can still be considered a valuable timber product. As far as posting goes, the landowner's name and address on posted signs, we believe that should remain a requirement of this law. Having landowners' contact information facilitates communication. So I don't see why we would want to remove the ability for forest visitors to be able to understand whose land they're on. It's just another form of communication. And I also realize it's not well followed by many landowners. They might put their name but don't want to put their address. And the other speakers are correct. A lot of times you can find it in the tax rolls, but that's only if those tax rolls and that tax information is online. Some towns do not have all that information online. So having landowners' contact information, it allows hunters who need to contact the landowner in order to retrieve wounded or killed game. Temporary access across posted property is also often needed for forestry operations, and again, this is another form of communication that a logger can use to contact the landowner to see if they can cross their land for operations. And then, of course, our agency is responsible for forest fire suppression, and again, learning the name and address of the landowner allows us to facilitate access for fire suppression activities. So the paint and the current posting law we feel is a well-established, time-tested standard for boundary marking used by licensed surveyors, foresters that are far more effective than the provisions proposed in this bill. And with that, I'll conclude my comments.
Representative Conley?
Thank you, and thank you for taking the question. I live in a small city, but a city nonetheless, so this isn't an issue I've given much thought to, but it seems like the property owners are being forced to do a lot of things to meet the letter of the law here, and I'm curious why we wouldn't let them choose a method, choose one or more method, or an alternative method to post their property versus what's in statute. I'm wondering what the harm is there.
The biggest concern, thank you for the question, Representative. The biggest concern is the confusion that it would cause. I mean, there are going to be very few visitors to the forest that are going to understand what purple paint is. Signs are typically the standard, posted signs. If you really want to send a message that your land is posted, that's what this law does. It provides the sideboards for that. Purple paint is just, as I mentioned, I've been a forester for three and a half decades. I've walked forests from northern Maine to western New York and everywhere in between. Purple's just not the color. I mean, it might be in other states, but it's just not going to be well recognized and cause confusion.
Representative Conley?
Thank you. Shouldn't it be on the onus of whomever intends to cross onto private property to make sure whatever the rule is, whatever the law is, that they are following the law before they traipse onto another person's property? And wouldn't this ensure that purple, orange signs I guess the question is, could they still achieve that? And shouldn't they still achieve that regardless of how it's marked?
So we have an open door policy in New England, as you may know, where if the land is not posted, then it's assumed that that individual can walk onto the land. So that's basically how it exists here in New England. So signage is the one way to communicate that. If you own land of any significance beyond a house lot, it behooves the landowner to paint their boundaries and make them very visible. And they do that with a blaze. A blaze is an axe mark that takes it down to the bare wood, and then it's painted with an all-purpose weatherproof paint that lasts between 10 and 15 years. So the onus is on the landowner to define their boundaries to ensure that no one trespasses, or at least they know they're crossing a change in ownership. But the color of the paint is traditionally does not communicate that it's posted. It just indicates you're crossing a boundary line.
Representative Roy?
Thank you, Mr. Chairman. Thank you for taking my question. Does the current statute require nails, or would zip ties work?
I don't think it requires how it should be attached to the tree, my understanding.
Representative Muse?
Yes, thank you for taking my question. One of the things I'm a little confused about is your standing here. So in your testimony, you said the Division of Forests and Lands manages 170,000 acres of state land. But what we're talking about here are private landowners, not the state. So does your agency actually have just jurisdiction over private landowners?
Thank you for the question, Representative. Part of our declaration of purpose as an agency, I'm sorry I can't see you with the speaker in the way, is that we promote a thriving forest products industry and good forestry. So we provide education and outreach to landowners as part of our mission. And so the interests of private forest landowners is baked into our mission. So that's why I'm here today, is to kind of represent landowners who are trying to manage their land, and we support their efforts, which includes maintaining boundaries.
Representative Muse, you're recognized for a follow-up.
Would you say, in terms of your relationship to private landowners, you consider yourself to be more of a resource for them?
Absolutely, education, information. UNH Cooperative Extension is a strategic partner in that effort, and they provide training. I don't say training, but they provide outreach workshops to private landowners, and funding comes from the U.S. Forest Service through us to Extension to educate landowners.
Thank you.
Yeah, you're welcome. Thanks for the question.
Representative Burt? Thank you, Mr. Chairman, and thank you for your testimony today. You've touched a little bit on it. Somebody sent me a message about if you could explain what common land rule is in New Hampshire compared to some of the other states, I believe, that have this law that do not have common land rule. If you could explain what that means.
Yeah, I don't know the definition of common land rule in the context of the previous speaker mentioned common land rule.
Mr. Chairman, follow-up?
Recognized for follow-up.
Thank you. No, they didn't mention that New Hampshire is common land rule, and you touched base on it that in New Hampshire, if the land's not posted, I can walk on it until asked to leave.
Yes.
Where some of the other states are not that use
Right.
this striping as a color.
Sure.
Yeah.
Yeah.
If you could just explain what, the difference between some states and New Hampshire is, that I'm allowed to do certain things where I'm not in other states.
Sure. All right. Thank you for the question. I don't have the knowledge in terms of what other states do. The first time I had heard that Pennsylvania does that actually they allow the landowner to paint it in purple. But I can tell you that is unusual in the Northeast. As far as the common land, private land ownership is obviously a cherished right of everyone in America. In New England, we do have it's actually a wonderful tradition that people will leave their land unposted to allow for responsible public use. And so I don't know if it's the same term, common land versus open door policy, if you will, or open gate policy. But that is essentially what it's been called for many decades in New England. Now that tradition is eroding, as we all know. More and more people are posting their land for various reasons. That's their right. But in New England, by and large, we still have a tremendous amount of open land, people that allow the public to recreate on it. Our statewide trail system, as you may have, is dependent on private landowners being willing to allow trails across their property. So it's a wonderful tradition, and we're trying to protect that by promoting responsible private use of responsible private use of private lands. You know.
Thank you.
Sure.
Representative Pratt?
I just have one question. You mentioned earlier machete slashing and painting.
Mm-hmm.
Is that an acceptable practice?
Well, machete would be probably not the most useful tool, but a blaze, yeah, we call it a blaze in forestry lingo.
So who does that? Lumber people? Timber people? Surveyors?
Surveyors do it all the time. Foresters can also do it, but it's considered a physical monument. Once that blaze is made, it has to be made by a licensed surveyor to become a monument. That can be painted, like I said, depending on the conditions of the forest. If it's high elevation, you probably have to paint at least every 10 years. If it's in a place where the weather conditions are not as harsh, every 15 years might be good.
Just one follow-up.
You recognize for follow-up.
So you have borderline trees. It's okay for a surveyor to come through and slash your tree and paint it?
Good question, thank you. So when you paint the trees, you really have to have physical monuments. Usually there's a previous blaze mark that you're working off of. If a landowner's not sure, if they don't have a licensed survey completed on their property, they would be well advised to work with their adjacent landowner to walk that line together. Okay. Yeah.
Thank you.
All right.
Thank you for your testimony.
You bet. Thank you.
The committee now calls Roy Schweiker.
Thank you, Mr. Chairman and members of the committee. I'm Roy Schweiker from Concord, and I'd ask your indulgence. I only asked for a couple minutes to speak, but I think I can answer some of the questions that have been given and respond to some of the things that have been said, so I'd like it a little longer. Anyway, this has nothing to do with New Hampshire, but it has something to do with marking land. For 5 years, I've been a volunteer for the National Park Service, maintaining the boundaries of the Appalachian Trail, which goes through the woods. And we have a boundary. It's a very long boundary. And there are volunteers that go out and maintain it. And we use a special yellow paint that has some special chemical in it that only the federal government can use, so nobody else can sneak up and put the official yellow blazes that we use. And the way it works is a licensed surveyor went through, they set metal monuments, and they blaze trees. And trees that are on the line, there's a blaze facing along the line. And trees that are within a certain distance of the line, there's a blaze on the side of the tree. All of these are yellow. And that's how the property is marked. And the problem we have is there are places where there aren't trees. And therefore you can't put blazes on them. So it's kind of hard to follow the line through there. If it's bushes, I go out and I put up surveyor's tape because that's not a legal boundary marker, so I can do it. But, of course, that doesn't last as long. And our experience with the Appalachian Trail is it's more like 5 years that the blazes start to fade. And remember that these blazes are bright yellow, so they're designed to be visible. And so, therefore, if the bright yellow paint with a special chemical is fading in 5 years, I think the landowners are going to discover that they're maybe not quite so good paint, it maybe fade quicker than that. And the other thing about it is we also have property signs we put up, and those are plastic signs, and they do degrade over time. They come loose and whatnot. We have to pick them off and take them away and put up new ones. And we do not use galvanized nails. We use aluminum nails. So if somehow that nail is left in the tree, it's less likely to affect a saw if somebody happens to saw into it. But the chief thing I want to say about this painting and putting up signs is far easier to go out and paint a section of that. You can't even do a mile in a day probably. Just going, finding every tree, putting paint on it. Whereas the signs, you can walk right along. She was talking about 100 yards. We do them usually every 200 feet because the monuments are 400 feet apart and we put one halfway in between. We can put up those markers a whole lot quicker than we could paint the thing. So painting is not easier, it's harder to the extent that the signs can stay up and don't have to be replaced every year. And as I say, we use the aluminum nails, so theoretically they won't damage the saw blades if the tree gets logged. And I don't know, I suppose you could use a tie, except a lot of the trees are too big around, you need an awfully long tie. And depending on the species, if it doesn't have the rough bark, maybe you could use staples, which once again probably wouldn't damage a saw and wouldn't go in very far into the wood. So I don't see that the signs are easier to put up, but you may have to put up one more often. And they don't damage the tree if you do it properly. And the paint may not last as long as people are talking about if you want it to be visible. You want this stuff to be close together. So anyway, that's my experience from Vermont on marking boundaries. The other thing I wanted to say has to do with this common land or whatever, that, that's left over from the Native Americans originally. They didn't own land, they just traveled through it and used it as they needed it. And it's in the British common law. It seems to have come into New England. And I like it. And an example in Vermont, if you think landowners have it tough in New Hampshire, in Vermont, you not only have to put your name on the sign, you've got to date it every year, and you've got to go to the town office and record it and pay what's a nominal fee. But it's a lot more trouble because in Vermont, apparently, they have this attitude that, land should be open, and they're willing to make it a little bit more difficult for the landowner if they want to post it for some reason. And as far as the signs themselves, my big gripe about them is you go to the hardware store, you can buy a sign that says no trespassing for any purpose, really cheap, and people tend to put those up instead of trying to indicate the particular things that they want you to stay away from. But, that's really a gripe. There's a lot of people now have found some way to get a sign that says no hunting with bear dogs because they're particularly opposed to that. But I'm sure that cost them far more than just buying a generic sign. And as far as contacting people, there's a place in Vermont that they put up a sign, no hunting without permission. That's great. That's not a legal sign in Vermont, but, like people have said, don't you want to do what the landowner wants? So I decided I would contact these people. Well, guess what? They didn't have their name on the sign because it wasn't a legal sign anyway. So I have to go first to the topographic maps to try and figure out where this is. That particular town had the tax maps online, so I was able to find out the parcel number. Then I was able to contact the town office. In Vermont, it is a public record, the owner of a parcel. So they were able to give me the name and address of the person who owned that parcel. And then I was able to contact them and say, can I go hiking on your piece of property? And I said, sure. But, that was a very convoluted system. And this is why it would be nice, once again, if people want their property to be used for the purpose they want, and if they want, people to contact them instead of just sneaking on, saying that sign's illegal, so I'm going to ignore it, it would really help if they would be, cognizant of the fact that some people might be interested in, doing the right thing. I'm not going to go hunt on your land with bear dogs. You have a sign that says that. But, how can I? And I'm not going to tell you, you've got things to do. I'm not going to tell you any more stories about dealings I've had with landowners. But anyway, that's my feeling. I think that the paint, like the previous gentleman said, is not going to be recognized, so it's not going to have the effect. It's going to be far more trouble to deal with than you think. The guy who buys that land and doesn't want to post it, that's another thing I've had experience with. It takes twice as much to cover up the paint as it did to paint it originally. he's not gonna do it, so that land's gonna be, out of the system forever just because one person put up some purple paint. So anyway, that's why I'm opposed to this bill. Thank you.
Thank you for your testimony.
The committee now calls Jason Stock, New Hampshire Timberland Owners Association.
Well, good afternoon, by 1 minute. My name is Jason Stock. I'm the Executive Director of the New Hampshire Timberland Owners Association. We represent timberland owners in the state's forest products industry. Our members own and or manage about 1 million acres across the state of New Hampshire. And our membership ranges from large, what I would say, commercial owners, folks like Weyerhaeuser, investment funds, real estate investment trust, to tree farms, 10 acres, and everything in between. And I would say most of our members' lands are open for what we call passive recreation, pedestrian recreation. And as you heard earlier today, that's kind of a New England tradition. But there are people that do post, and they post for a variety of reasons. Either they create safety zones around livestock, their buildings, their homes, things of that nature. But I've come here today to speak in opposition to this bill, and for a couple reasons. And I'm not going to belabor it, but you've heard some of it already. There's a question about recognition. One of our members has land in the state of Maine, which allows purple paint. And when I asked him about it, I said, what's Maine's experience? He said, his words to me were, it's kind of a joke over there. People don't really know what it means. It's not part of the traditional land use. And he says it almost for that landowner, it creates more of an issue than solves. People understand, they recognize signage. The signage can get very explicit in terms of no bear dogs, no posting for any reason, etc. So it's, the posting itself, we believe that the current process works. And as you heard from the state forester, there are reasons why you want to have a landowner's name and at least contact information up there. And, opportunities or reasons where you want to facilitate that communication. A game animal travels over onto your property and it's posted, I'd like a heads up. Okay, you're going to retrieve that deer, great. The other piece is why you would want, as you heard earlier, fire suppression, contact them, something's going on out there, Mr. and Mrs. Landowner, we need to contact you. Many of our members' lands are in remote areas, so access to tax maps and Wi-Fi hotspots or internet access, it's not really an option if you're on the backside of Smarts Mountain up in the Canaan area. Wi-Fi access is just not an option up there. But if you have a name up there and you have an address, it's a heck of a lot easier to kind of locate who the person is and kind of track them down if you need to talk to them about accessing their property. And again, as you heard earlier, the property sold, the paint remains, and now the new landowner has to deal with it. Granted, it could be a condition of sale, but it's just another variable in the mix. So I guess I'll conclude my testimony there. You've heard it. You've heard all the reasons why this bill we don't feel it's necessary. Is one of my policy committee members said this is a solution looking for a problem. Right now, we have a posting process. We have a tradition of open space and land use. It's working. We really don't. The feeling is this bill is just not necessary. With that, I'll conclude my testimony. I'd be happy to try and answer any questions.
Representative Roy?
Thank you, Mr. Chairman. Thank you for taking my question. I wonder if there isn't some room for compromise. What if the statute were changed so that you extended the distance between the necessary posting of the name and we're allowed to purple paint, say, for 200 yards or 300 yards, and then you had a sign with the name, so that someone could take the time and walk a little bit further and find the person's name, yet save the homeowner the burden of having to put signs every so often, as it is now. How would you see that?
I guess the way I mean, I'm certainly open to consider, I guess my point, though, in coming here today was that the current process works. Again, it's been established over many, many, many years. People know what the requirements are, and if it ain't broke, why try to fix it? It's kind of our approach to this.
Thank you.
Representative Muse?
Yes, one of the things I'm curious about is we've heard a lot of talk today about what's required of people who want to post their land, and the idea that people, that contact information is a good thing to have and it's necessary and it helps people out. I think I can understand. What I'm curious about, though, is it sounds like the vast majority of private land in New Hampshire is not posted. So in a situation where land is not posted, how do you get in touch with somebody if you have, a fire protection issue or one of these other issues where you find it helpful to have information about the landowner?
Sure, great question, and thank you for asking. I think what we're talking about here is slightly different in the sense that when you post a piece of property, you can't access that property. You can't access that property without permission. If the property is not posted and you need to access that property, you can, particularly if it's a situation where you need to access it and there's a time factor there. You've got a game animal, you've got a fire situation, and in that instance, there's no question you can access it if it's not posted. What we're talking about here is this darn speaker, if it is posted, all right, before I can do what I need to do, follow the animal or deal with the fire situation, the posting adds a step. So the point is, if you're not posted, you don't have that step in there. Once you post it, now you have this landowner notification step, and for that reason, having the name and address is important.
Representative Burt?
Thank you, Mr. Chairman, and thank you for coming and testifying today. To go back to, the posted signs, it's obvious that it's a wooden sign. Well, most people put them on plywood and then nail them up. But would it be easier for somebody that wants to break the law and to say, hey, I'm going to post all this property even though I don't own it, with a wooden sign or with just a spray paint?
Obviously, I think splashing paint is easier than going through the effort of creating a wooden sign and putting it up on, be it a tree or pole. So my answer would be, I think, my opinion, the paint would be easier to apply than posting a sign, as you had said, on a piece of plywood onto a tree. Most of the postings that I see typically don't use plywood, but even so, the paint would be, I think the paint would be easier, but you heard testimony. I haven't done either. I own land. It's open to recreation. I encourage people to use it. So I can't tell you from personal experience.
Thank you.
Representative True?
Thank you, Mr. Chair, and thank you for taking my question. Are nails in trees a problem for the companies that are harvesting trees?
Nails, yes. Nails are problems in trees. You talk to any lumberman, and well, you go into any lumberman's office, and they usually have a little bookshelf with all the little things they find in trees when they open them up and saw them. But as you heard earlier, there are ways around that using aluminum nails, which are softer than steel. Saw blades are made of steel. There are other types of nails and types of staples that can be used, but metal nails you know, steel, particularly steel in trees. If you're going to cut it for lumber, that's a problem.
Thank you for your testimony.
Thank you.
The committee calls Major Walsh, New Hampshire Fish and Game.
Good afternoon, Mr. Chairman, members of the committee. My name is Dave Walsh. I'm the Assistant Chief of Law Enforcement for New Hampshire Fish and Game Department. First, I would contend that probably nobody deals with posted land and posted land issues more than a conservation officer with Fish and Game. The other thing I think that I hope you would all agree is outdoor recreation is a huge part of New Hampshire's economy, and it's a huge part of New Hampshire's way of life. The first thing I did when this bill came out is I called the state of Maine. They implemented the purple paint law in 2011, and I called the Maine Warden Service and asked, how is the purple paint law going? And they laughed, and they said, utter chaos. They find more hunters and hikers on purple painted land because they have no idea what it means. And that's been in place now for 10 years, for a decade. A lot of the points that I'll make, I'll keep short because they've been brought up again, but if a landowner sells land, which happens a lot in the state, and let's say it's 200 acres and it's painted purple, and the new owner comes in and they want to keep that land open to outdoor recreation, that's a lot of work to either scrape the bark or go around with brown paint and cover it up. And to someone's point earlier, many of those landowners might not do that effort. So they don't want to post their land, but now we have unintended posted land because they don't want to go through that effort. And unintended posted land is not what we need in the state of New Hampshire. The other thing is, if a landowner changes their mind, let's say they post their land with purple paint, and then they decide they want to have some current use, some land in current use, and change the allowable uses on the land, outdoor recreation. Now they got to go through that effort again. Or many landowners will allow certain things. They might allow hiking, but not hunting. So now they're going to have to go through this, the purple, and if they've already had purple paint in their land, they either have to cover up that purple paint or put a sign on it or next to it. And now if you have purple paint next to a sign, what came first? And it's just confusion to people. As a previous speaker said, the system works the way it is, and it's nothing that we condone. And I'd be happy to answer any questions.
Representative Conley?
Thank you. And thank you for taking the question. We've heard from landowners who say the system is not working. And we have two in the room, and I suspect there's many more across the state who would love to not have to deface their trees and their property and walk the perimeter and so forth. So I guess I'd ask you the same question. Is there harm in giving them a choice in the means that they would mark their property, which would be their right as a property owner?
Sure. So I've been doing this for 24 years, and I can tell you the vast majority of people that do post their land use Tyvek paper with staple gun or aluminum nails. So the tree issue isn't an issue from what I've seen in my career. I agree with Representative Roy that there could be some room to add some signage with purple paint, but if it's just paint, all I see is confusion, and I don't see it working.
Thank you for your testimony.
Thank you.
The committee calls Joan O'Brien.
Thank you, Chair, members of the committee. So I've just been listening here, and I actually did quite a bit of research into this because I'm one of these people that had difficulty posting my land. I'm not quite as short and skinny as this woman before me, but close. And it did take a ladder. And I did have to go around the year later, and I saw that all my Tyvek signs had folded in, so I invested in better plastic signs, which cost me a lot, and went back and did all my labor again. But what I wanted to say mostly is that this is about landowner rights, and the practice is spreading throughout the country, and I think for the same reasons we want it here, the rest of the country is finding that they need it as well, and we've got more than half the states now with either laws or legislation that they're considering. And that includes, in the Northeast, we've got Maine, which was mentioned, Pennsylvania, and both New York and Vermont currently have legislation that they're considering. to add the purple paint law as well. Whenever there's a change, there's some public education that needs to happen. And in searching, I saw that the local news and the newspapers would cover, you know, if the law passed, they'd have a little spot on the news that said, you can now, you know, post your property with purple paint in Pennsylvania or whatever it was, and the newspapers cover it. And I think New Hampshire Fish and Game is extremely good at public education, and they could spread the word that way as well. Let's see here. The paint itself, you can buy it from Rust-Oleum, you can buy it from Krylon. There's another company called Magic that makes it, so it's widely available in Lowe's, Home Depot. It's a thing, and people will get used to it, and they'll see it, and they'll start to learn what it means, and they'll read things, and they'll hear from Fish and Game what it means, and they'll get with the program. And I think that's all I have to say. Thank you very much.
Representative Newman?
Thank you, Mr. Chairman, and thank you for taking my question. I'm a representative from Nashua, and there's not a lot of hunting in Nashua, so maybe you can educate me just a little bit. Could you speak to, I don't know about hunting licenses and whether residents or non-residents need them, but could you educate me or give me your opinion about if when a license is gotten, when somebody gets a license, if in fact they do, could this type of education be handed out when the license is given to the person, explaining what purple paint means?
I would imagine, I mean, you need to know a lot if you're going to be a hunter. You need to know all the dates, all the seasons, all the bag limits, so it's just another thing that you need to learn about.
Thank you.
Thank you for your testimony. This time, we'll now close the public hearing on House Bill 1108. And the committee will be in recess to 1:10 p.m. Just in case we want to executive. 5 minutes. You already swiped mine earlier. I need my nap shots.
Yeah.
Good afternoon. At this time, we will now open the public hearing on House Bill 1433 relative to the penalties for poisoning dogs. This time, the chair recognizes Representative Sullivan to introduce the bill.
Thank you, Mr. Chairman, and thank you
just
to the
pass it up.
committee. Representative Brian Sullivan. I represent Sullivan District 1, consisting of the towns of Grantham, Springfield, Plainfield, and Cornish. And it's my pleasure to be here to introduce House Bill 1433. You may remember me from last year when I came to introduce House Bill 338. That bill was a related topic. It dealt with dog collars. And it's sort of relevant to this bill as well, because I wouldn't be here if it weren't for that bill. Basically, House Bill 338 last year was heard by this committee, amended by this committee, and passed by this committee. And of course went on to the other body. When it arrived there, they also had a hearing in the Energy and Natural Resources Committee. During that hearing, there was a concern raised by the co-chairs of the Governor's Commission on Humane Treatment of Animals. The bill that was in place addressed tampering with dog collars and removing microchips. The concern really didn't deal with either of those issues. It dealt with the poisoning of dogs. So once the hearing was over, I got a call from the assistant to the chair and was asked if I could get together with those co-chairs to discuss their concern. We did that. We had a conference call, and we came to an agreement. They would either, I'm not sure if it was they agreed to support or at least not oppose House Bill 338, and I agreed to address their concern this year. So here I am. House Bill 1433 seeks to do three things. First, it seeks to place poisoning of animals, including dogs, in RSA 644, the Criminal Code, under cruelty to animals. It also seeks to repeal the section of RSA 466, :42-A, that deals with the poisoning of dogs. It further repeals RSA 644:16 to allow poisoning of animals to be moved to Section 8 of RSA 644. It is primarily a housekeeping bill and essentially puts the poisoning of dogs in with the poisoning of animals in the proper statute under criminal justice or criminal code. Geraldine Zazzulo, co-chair of the Governor's Commission on the Humane Treatment of Animals, is also here to testify. She was the motivator behind this bill and can go into more detail as to why they sought to have this take place. But it was my pleasure to bring this bill on their behalf, and they're a joy to work with. With that, I'll take any questions you might have.
Representative Newman, you are recognized.
Thank you, Mr. Chair, and thank you for taking my question. And it has to do with the, on page 2, lines 4, the removal. It lists what's repealed, and my confusion is when stuff is bolded and not bolded, and when it's in the real, with the current law, or is it a new stuff that is just not bolded for some reason? And if someone else you think might have better knowledge to talk about that, I'd be happy to wait till someone else is there.
The bill as printed is a little bit difficult to decipher. On the first page, you will see the bold printed material. And that is indeed the new section on poisoning of animals, not necessarily just dogs, but poisoning of animals. Then at the very end on page 2, it very briefly indicates that it would repeal RSA 644-16 relating to the exposing poisons to animals, and RSA 466-42-A Roman 2 relative to the poisoning of dogs. So it essentially repeals those two pieces and puts the poisoning of animals in the current statute here, RSA 644:8.
Thank you.
Representative Conley?
Thank you. If I may piggyback on my colleague from Nashua's comment. So one of the things that I think Dover residents are least proud of is we've had a problem with rats, a lot of development and a lot of rats, and people are taking it upon themselves to place poison out in the neighborhood and so forth. And I'm wondering about that last section that you just described. What sort of intent would be required to be caught up in this if an animal were to ingest this substance that was placed around one's property but had an effect on an animal other than a rat?
As I understand it, if you intentionally poison the types of animals covered by this, which would be domestic animals or wildlife in captivity, it would be probably deemed a negligent act. I'm sorry, if you intentionally do it, it would be a higher penalty than if you do something by accident. Negligence, I believe, is a misdemeanor. The intentional poisoning of an animal would be a felony.
Representative Roy?
Thank you, Mr. Chairman. Thank you for taking my question. I hire actually an extermination company. I live out in the woods and we get field mice. And they come and they put these bait traps around the foundation of my house. Now, if my neighbor's dog comes over and chews through one of those and eats the poison, would I fall under the negligent poisoning of an animal in the statute or no?
I'm not law enforcement, so I'm not sure exactly how that would be treated, but I would say there's potential for that.
Thank you.
Representative Spillane?
Thank you, Mr. Chair. Thank you for taking my question. Much like Mr. Roy, I live out in the middle of nowhere, and my closest neighbor's a quarter-mile plus away. It's not uncommon that I find the neighbor's dog in my yard, especially since I also have a dog. And I am frequently putting out poison for mice around the foundation of my house and or in my garage. Should their dog decide to eat my poison for the mice, even if it's in a controlled box, why should I be liable for their dog coming on my property a quarter-mile away when there's leash laws in the town? I don't see anything in here that basically says if you're on your own property and you're poisoning on your own property, that there's no negligence here.
I think you're right. That basically law enforcement would have to evaluate whether or not that dog being on your property that far away from their place, not on a leash, might be a mitigating circumstance. But again, I'm not law enforcement.
You're recognized for a follow-up.
Thank you for the follow-up. If we purposefully put into law something that makes somebody liable for that type of behavior, and then we say it's up on law enforcement to mitigate that, that's an injustice to everyone in this state. We need to ensure that our laws are correct before we enact them.
I would also point out that poisoning of animals is currently in the law. What this bill intends to do is to move it from one part of the law to another so it's more easily identified in the cruelty to animals section.
Representative Burt?
Thank you, Mr. Chairman. I do have a question for the representative, but if you wouldn't mind if I have a question for you first, Mr. Chairman.
You recognized for a parliamentary inquiry?
All right, thank you. If I'm reading first page, line 15 to 19, I'm reading it as if I put poison out to protect my building or crops, that I am not going to, I'm exempt if a dog comes onto my property. Am I reading that wrong?
Excuse me, the way I interpreted this, and this is my interpretation, which I'm not testifying, I'll just point that out. It's not really a parliamentary inquiry, might I add. But it seems to have an exception if you put out some type of poison control to deal with rats or other type of vermin. So it allows an exception for that. I would just tell any member of the committee since I'm answering a question, and since we all just got our updated books recently, I know there's some subs, but if you look at RSA 626:2, Roman numeral 2D is the definition of negligently, which may also help understand the application of this if it were to become law. So that's a person acts negligently with respect to a material element of an offense when he fails to become aware of a substantial risk and unjustifiable risk that the material element exists or will result from his conduct. The risk must be of such a nature and degree that his failure to become aware of it constitutes a gross deviation from the conduct that a reasonable person would observe in that situation. So that's just from an application line.
Yes. And if I may ask the...
You may ask the witness a question.
Okay, thank you, Mr. Chairman, and thank you for clearing that up. And thank you for your testimony. I think I'm a little confused too, like, the first speaker about what is changes, and I'm looking at lines 25 and 26, and then also 27 through 30. Is what is not bolded, is that current law?
Absolutely, yes.
All right, so what follow-ups?
You recognize for a follow-up?
Thank you, Mr. Chairman. And so it's just the words being added, and I was also looking at line 2, which is currently, if somebody is found guilty of, and this is current law, if I'm understanding this correctly, if somebody poisons an animal, it's a misdemeanor first, then second offense would go to a felony charge. Is that?
That is the current law, yes.
Okay, thank you. So we're not adding anything.
The only things that have changed in RSA 644:8 is what is bold.
Thank you. I appreciate you clearing that up.
Representative Spillane.
Thank you again, Mr. Chair, and thank you for taking my question. My further question comes from the specificity of and persons using poison to control rats and other vermin in their building or to protect their crops. I raise chickens, and I frequently put out poison in the chicken coop or around the chicken coop to prevent rats and vermin from going into the chicken coop to either steal the chicken feed or to go after the eggs from the chickens, which they will do. There's nothing here to protecting livestock, protecting the value of your reap from your livestock and or crops. It only deals with crops and buildings.
Representative Spillane, is there a question?
Yeah, does this apply also to protecting of livestock with poison?
I think I would defer to the next witness on that. She's far more familiar with the humane treatment of animals than I am.
Thank you, Representative, for your testimony.
The committee now calls Tara Lee from the Governor's Council on the Humane Treatment of Animals. I'm sorry, I can't read your writing.
If you don't mind just spelling your name for the records so the clerk can. Thank you.
Is that on now? Okay. My name is Geraldine Zazula. I'm co-chair of the Governor's Commission on the Humane Treatment of Animals. On the commission, I represent the general public. The Governor's Commission looks at any new legislation coming through to see if and how it affects the welfare of animals. And every legislative session, we go through basically any new bill that may have the word animals in it to see if it's going to affect the humane treatment of animals. As Representative Sullivan indicated, we had an issue last year with the bill that was primarily for tracking collars and microchips, but we found an issue with the poisoning of animals. And we also were aware of another statute that was in the wrong place as far as where it was in the criminal code. So as he mentioned, he gave you the history of it, so I'm not going to go over that again, but I would like to speak to what's actually going on here and talk about the pieces of the puzzle. In your handout, there's a blue sheet that has the beginning of the Animal Cruelty Act. Okay, and you can see that the definition for animal cruelty is very broad, and the poisoning of animals would definitely come under that category. It is gives a list. It says cruelty shall include but not be, and then goes on from there. It also defines animal, and these are very important definitions in that law. In the 644(8) in the animal cruelty law, an animal is a domestic animal, a household pet, or a wild animal in captivity. It's not a free-living animal. It's not wildlife. It's much more than dogs, just dogs, which is what was in the bill that was passed last year. Okay. Now, if you go to the actual bill that you have, this goes on and goes down to Roman numeral 3. So you've got Roman numeral 1 in front of you on the blue sheet. We're going to skip down to 3 because that's where the germane actions are. And it talks about a person is guilty of a misdemeanor for a first offense and of a Class B felony for a second or subsequent offense. And then it gives you a grocery list of actions that somebody can take that constitute cruelty. And you notice they all begin with the word negligence, negligently. And Representative Abbas brought up the fact that there are culpable mental states for each offense in the criminal code. There has to be a reason for that happening. So the first part of the cruelty law talks about negligent actions. And there's a whole bunch of them. Some of them are very old terminology. But an example is without lawful authority, negligently deprives or causes to be deprived any animal in his possession or custody, necessary care, sustenance, or shelter. So that's an example. So we're proposing to put poisoning in this list, okay, of the negligent offenses. And I'll talk specifically about the language for that in a minute. Now, if you go down and look on line 28, Roman numeral 3A, we have another set of offenses to the cruelty law. And these offenses are, have a higher penalty right off the bat. It's a Class B felony. And that is for individuals who purposely commit an action against this law. And there's a little grocery list of just 5 items: beats, cruelly whips, tortures, mutilates any animal, or causes an animal to be beaten, cruelly whipped, tortured, or mutilated. And we'd like to add poisoning to that list. Okay, so those are the basic changes we'd like to make in the cruelty law. We feel that poisoning belongs in this list and nowhere else in the statutes. Now, on the back of the first sheet that I gave you, we have copies of the laws that we're going to be repealing, so you can understand why we had an issue with that. Now, the first law is in the Civil Code. It's under the Chapter 466, which covers dogs and cats. It's under the auspices of the Department of Agriculture, Markets and Food. So the second paragraph there, stealing dogs and tampering with collars, is the bill that Representative Sullivan talked about that was passed last year. Okay, and if you look at Roman numeral 2 under 466.42, it says, whoever distributes or exposes a poisonous substance with the intent that the same shall be eaten by any dog shall be liable to the owner of the dog's owner for its value and shall be guilty of a Class B felony. So, first of all, it's just dogs, no other animals. And it just talks about the fact that it is, does not address a culpable mental state. That's not in there at all, which is what we need for a crime. It has only one penalty, Class B felony, and it only talks about ingestion of a poison going in by mouth for the most part, okay? So the Governor's Commission feels that this should not be in the Civil Code. It should be part of the Criminal Code and part of the animal cruelty law. Okay, if you go down and look at another statute that's in the Criminal Code, 644.16, this is an old law that's in there, but it's not in the section where the animal-related crimes are. It's someplace else off by itself, and it's called exposing poisons. And it's, if any person shall in any way or place purposely expose an active poison or deadly substance for the destruction of any animal or for any other purpose except the destruction of rats, other vermin in his own building or upon his crops, he shall be guilty of a violation. Okay, so that's there. It only talks about exposing poisons, and the penalty is only a violation, which, as you know, is a fine. And again, the Governor's Commission felt that that was not appropriate and that it should be moved up to the animal cruelty statute, which is 644.8. Okay. Now, we do feel, and hopefully you understand where this is coming from, that a person that purposely tries to poison an animal as defined under the cruelty statute, which is domestic animal, household pet, or wildlife in captivity. Anybody that purposely tries to poison an animal should be guilty of a felony offense. They're doing that on purpose. Now, it does not cover any wildlife, doesn't cover mice, rats, whatever. they're not covered under the animal cruelty law. Okay, but somebody that's trying to poison domestic animal, household pet, or wildlife in captivity, the Governor's Commission feels that that should be a felony offense because it's intentional, it's purposeful, and it's meant to harm the animal. So if we go back and look at the actual bill again, I'd like to talk to what we did with the language of the cruelty law. So I'm looking at the bill. I'm starting with line 15, and I'll talk through what each of those parts of that 2 sentences mean. Okay, so we're adding to the misdemeanor grocery list that it's a misdemeanor for a first offense and a Class B felony for a second or subsequent offense who negligently poisons an animal by exposing, distributing, or administering an active poison or toxic substance causing harm or death to the animal. Okay? Then we tried to address some of the concerns that have been brought up here. One, and give some exceptions. Substances administered in accordance with RSA 332B. This happens to be the Veterinary Practice Act, so that if somebody is administering a medication and the animal has a side effect, that the veterinarian is absolved from that, because it's, as you probably watch TV, every drug has possible side effects. Okay? And then we also added the exclusion, persons using poison to control rats and other vermin in either their building or to protect their crops shall be exempt from this subparagraph. That's a direct quote from the old law that we are hoping to repeal, the exposing poisons. So that would absolve your chicken coop, any of your property. It would allow you to do that as long as you were dealing with just vermin. Now, the definition of vermin by most dictionaries is any of various small animals or insects that are destructive, annoying, or injurious to health, such as cockroaches and rats. And so this allows exterminators and nuisance wildlife operators to come in and protect your property. There's no penalty for that. Now, if a neighbor's dog gets in there, that's on them. You know, that's their problem. It's your property. The animal is trespassing at that point, and if they get poisoned, that's on them. Okay, so that we put in the negligent category, but we also repeated it down in the felony category. Now, so it's repeated under the felony category as well. Okay, so those same exceptions apply under after line 28 when we're talking about felony offenses in the Cruelty Act. Okay. This bill proposes 3 changes that would strengthen the current cruelty law and remove poorly written felony offense from the civil law and remove an outdated statute with an inappropriate penalty. So we're doing 3 things with this bill. Okay, so I hope I've clarified some of the issues and questions.
Representative Blaine.
Thank you, Mr. Chair, and thank you for taking my question. Would you call polypropylene glycol a toxic poison?
Antifreeze? Yes.
So if I were to have a spill in my driveway
recognized for
and
a
then
follow-up?
follow-up? So if I was to have a spill of antifreeze polypropylene glycol in my driveway and the dog next door came over and licked it because it does taste sweet and poisoned themselves, would I then be eligible for potential prosecution under this law because I negligently did not clean up my spill?
That's a good possibility, depending on how the investigation goes.
Follow up?
If, can I continue for a minute? If
You may answer the question.
If it's an inadvertent spill, chances are there would not be an issue. If you were working on your car and you knew there was a spill, there may be an issue if you didn't clean up. There are accidents that happen.
Follow up?
You recognized for follow-up?
Thank you, Mr. Chair. Would you consider chocolate toxic to animals, dogs specifically?
I would.
Follow up? Mr. Chair, am I recognized for my follow-up?
Yes, last one.
I'll have more questions later.
We generally, we want to, you asked the question, now you changed the stuff.
There are a number of issues, Mr. Chair, that need to come out on this, because there are a lot of toxic substances to animals that have been now broadly categorized in a situation where very few people have control over them. And I would like to bring them out. And we have a reference to an RSA down here that applies only to veterinarians, whereas a lot of medications are now purchasable online and or through Tractor Supply down the street, applicable to be administered by the owner of the animals or livestock, and they would not be protected by this.
I understand the point that you're making, but with that point, I mean, just in going substance by substance, we could be here. That's what I was trying to do.
I'll try to put them all together.
Put them all
How's
together.
that?
That would be.
Thank you, Mr. Chair. Would you consider chocolate, onions, garlic to all be considered toxic substances to dogs?
May I give a broad answer rather than a specific answer?
You may answer any way you wish.
Okay. We're going back to the requirement of culpability, and it's the term negligently, and it's a gross deviation from conduct that a reasonable person would observe in that situation. If it could be proven that the person administering any of those substances to an animal knew that they were poison, yeah, they would be possibly liable under this. I would say that probably most poisoning is inadvertent. It happens at home by the owner, and it's never going to get reported unless it goes to the animal, gets a very thorough evaluation by a veterinarian, determines what the toxic substance was. It's not going to be an issue. What might be issues are things like golf courses using fertilizer that runs off into your farm's pond and your animals drink it. Things like that that are not meant to poison the animal, but could.
Follow up?
Can I ask one?
Go for it.
I have one question. There was a question about having a chicken coop. So I'm referring to lines 18 where it says, other vermin in either the building or to protect their crops shall be exempt. The way I interpreted that was to not include a chicken coop. So I just didn't know if
it's basically on their property.
Would, if I may ask a follow-up,
Yes.
thank you for taking my question. If the term building was changed to property, would that have any impact on the intent of this bill?
We basically transferred the terminology from 644-16. In his own building or upon his crops, he shall be guilty. So building and crops is related to homeowners, farmers, those types of things.
The legal question may be, is the chicken coop considered a building? So I think that's a simple fix in the drafting, but I just didn't know.
The coop itself is a building, but the eggs and feed inside it is not.
But I don't understand if you're distributing, putting out rat poison or mouse poison. It's on your property, by your buildings. It's to protect your property. It's exempt from this.
I think the chair was getting at the fact that sometimes you put the poison out not in the building or directly surrounding the building, but you put it out to deter to the building. So it could be anywhere on your property.
Right.
Representative Burt, you're recognized.
Thank you. Thank you, Mr. Chair, and thank you for your testimony. If I'm reading the bill correctly, now that I understand what is new and what is not, what basically this is going to do is if I put out, which I don't use because I have chickens, I don't use rat poison, but if I put out rat poison in a box and a dog chewed into that, I'm not going to be held liable.
Right.
But if a neighbor is sick of listening to his neighbor's dog barking 22 hours a day and he throws poison over the fence, then that guy purposely did it and will face these charges.
Exactly.
Thank you.
Representative Newman?
Thank you, Mr. Chair, and thank you for taking my question. In the line, the bolded lines that you're talking about, it makes reference to RSA 332B.
Correct.
And it says in accordance with RSA 332B, and it has 20 subsections to it, and I'm trying to find out which one is the right one that it's actually pointing to, and should that in fact be in
It's basically if it's part of a patient-client relationship with a veterinarian. If that animal gets a hold, is being treated for something that turns out to be toxic for that animal, then the veterinarian is not liable. It has to be prescribed by a veterinarian as part of a veterinary-client relationship.
Representative Newman, you're recognized for a follow-up.
I guess my follow-up is we're talking about putting out rat traps or something. Would people that are putting out poisons that they bought and didn't get prescribed by a veterinarian be exempted in 332B? Is that the right place it should be, or do I just don't understand?
Well, if you are using insecticides for ants or you're doing rat traps, for your property, you're exempt. It would be an accident if your animal got a hold of it. It's not a crime. You're allowed to protect your property.
Could I have one more follow-up?
You were recognized for a follow-up.
Yeah, thank you. And I guess just the problem is this bill describes to people how they can be exempt from that, and it points directly to RSA 332B.
No,
And
it's two exemptions. One for 332B, and that's the veterinary-client relationship. And another one if you're protecting your property from vermin. They're separate.
But in both, follow-up?
Recognized for a follow-up.
In both of the places, the only RSA I see referenced in the law, as it's written here, is 332B. And I guess I'm probably not asking the question right. I cannot find any language in the bill that exempts a person who is not a veterinarian from the penalty. I just can't find it in the law, and I have a problem with that.
Okay.
So it may need a definition or something like that. I don't know, but I just cannot find something that allows me to follow what I'm supposed to do in accordance with it. If
Okay.
I can't find it.
It says persons using poison to control rats and other vermin in either their building or protect their crops shall be exempt from this paragraph. It's a direct.
Is that in the bill, or what are you referring to?
All right. First of all, I'm just going to go over this quickly, and I feel like we do it every meeting, but we'll do it again.
Thank you, Mr. Chair.
In order for anyone to speak, they need to be recognized to speak. as you could, if you want a follow-up question, you may ask. We are not permitted to debate members of the public. We only ask questions to gather information about the bill or to clarify their testimony. That is it. Any other questions will be out of order. Anyone who's speaking without being recognized, I will rule them out of order. But Representative Newman, you are recognized for a follow-up question.
Thank you, Mr. Chair. I don't have a follow-up question. I'm just confused and probably will vote against it.
Thank you for the heads up. Representative Green, you're recognized.
Thank you, Mr. Chair. Thank you for taking my question. What if a dog was in an area where he was exposed to either marijuana or ingredients of marijuana and digested those? How would this be handled?
This is not an uncommon occurrence, and marijuana, depending on the dosage, or CBD, depending on the dosage, can be very toxic to animals. Now, this may happen in the home, and it may be the homeowner that's at issue with this. So ideally, a responsible owner would take their animal to the veterinarian, and the veterinarian would do a history and figure out what happened. It would probably go no further than that, unless the veterinarian wanted to turn them in. Now, if it's your roommate and you want to turn them in, that's up to you, because technically a crime would have been committed if the animal became sick or died from it.
Follow up?
You're recognized for a follow-up.
New Hampshire, like other states in our area, is pushing for marijuana, legalizing it. And if people will start to grow this product, that's what I'm asking.
I don't find that question germane to the bill.
Well, it would be more available.
Whether it's cannabis is legal for recreational purposes or not, it can still be considered a poison, just like alcohol. It can still be poisonous and be legal for recreational purposes. So we don't need to get off track on the subject of cannabis. So
Well, I'm just wondering if we're growing it, if it does pass and we're growing it and dogs get in there, who's going to be at fault? Thank you for taking my question.
I'm deeming the question out of order. And Representative Burt, you are also out of order for making the pizza comment.
I do apologize.
I'll apologize to the witness on behalf of everyone. Representative True, you're recognized.
Thank you, Mr. Chair. And thank you for taking this question. I was political science, not pre-med, so I appreciate your explanation of why you're making changes. I understand why you want to, why RSAs are being repealed. Again, what I don't understand, ma'am, is why the new language is being put in. I would think just by repealing, without the new language, it covers mistreatments of animals being dogs and household pets, and it's already covered by all of that. I think maybe that's adding to some confusion. If without it, I see that the poisoning would still be covered, even without these new, without the new wording being put in. Is that incorrect? That I mean, if you accidentally poison a dog, that's mistreating, causes animal, it's mutilated. It seems that the words are already there, even if the bold letters were taken out.
That's a very good question. And probably as far as the misdemeanor negligent offense, you are very, very correct. In fact, when I recommend that when animals are poisoned, that law enforcement use the cruelty law rather than the current one that we're repealing, the older one, 644-16. But one of the issues is if you get down to the line 28, 3A, if you look at that list of felony offenses, those are words that come directly from up above the negligent offenses. Okay? So in order for it to be a felony, it's got to be a word in there, and that word is not up above in the misdemeanor offenses. So we would need to add it, and then in looking at adding it, when laws are written now, we like to put in definitions and explanations rather than just words, because those can be misinterpreted. And that's why we put exposing, distributing, or administering an active poison or toxic substance, and why we put in the exceptions, because there are instances when it would not be an issue. Does that help you?
The two representatives are having a conversation, so we wouldn't want to interrupt. When they're done, I'll recognize you for a follow-up, Representative True. That's relevant to the witness's testimony.
Thank you, Mr. Chair. Thank you, ma'am. I would say, being a political science major, that purposely poisoning a dog is torturing that dog. If you don't kill it, it's going to be violently ill. You're causing severe reaction from the dog, for the dog. The dog's being tortured. He may even be tortured to death if you purposely give him poison. So that's why I'm thinking it's already covered. I just thought it would be a lot cleaner if we repeal these RSAs. Thank you very much. That's
the Governor's Commission has a lot of issues with the terminology because it's not defined, and torture is one of those words. We're aware of things that are happening that are not covered in this bill for the felony offenses that can't be proved in a court of law. If you look up the word torture, you're not going to find poisoning in there. If you look up, we have issues with starvation as well, because that's not in here. I mean, it's covered because they're not providing food, but it's not a felony offense right off the bat. So there are a lot of missing pieces in this law that someday we would like to correct, but that's why we put poisoning there.
Thank you, ma'am.
Thank you for your testimony.
The committee now calls Angela Ferrari, dog owners of the Granite State.
Good afternoon, Chairman, members of the committee. Thank you for giving me the opportunity to testify on HB 1433. My name is Angela Ferrari. I'm here representing dog owners of the Granite State. We are an AKC-affiliated nonprofit organization founded in 1991 to represent the interests of all pet owners in New Hampshire. and we have a wide variety of membership, from pet owners to breeders to various clubs for sporting dogs, etc. Dog Owners of the Granite State opposes this bill as written, which, might surprise you since we do represent the interests of dogs and their owners. However, as you've had great discussion on already, our main concern is around the use of the word negligent and the section F that's been added here on line 15. With so much variety and ability for somebody to accidentally have poisonous substances around that could affect a dog, we feel that this sets up owners, friends of owners, neighbors, too much to be pulled into this for a criminal penalty as a misdemeanor. So it's too open to interpretation. I think we've already had a lot of trouble discussing each of the various poisons that could be considered part of this bill and how that would be considered negligent actions or not. With the inability to say if these different actions would actually be considered negligent, we heard the word purposefully a lot. And that's a totally different section of the bill, and negligent versus purposely is very different. So while we do not support the addition of negligently poisoning animals as part of this bill, we do understand the changes that are being made in regards to purposeful poisoning and adding poisons to the section that starts at line 28 in the bill. However, as raised by Representative True, we do believe that the existing laws do cover purposeful poisoning with the use of the language that is already in 3A, and that goes for torturing, mutilating, and even up above in I, where it says unnecessary suffering of any kind. So we feel that poison is represented with our current law, and we would be okay with the two sections being repealed and adding poison there if you felt, as a committee with your experience in how the law is written, that it would be cleaner, reduce any confusion, or remove any loopholes that may be there with the existing statutes, but we don't necessarily believe that it is required. So we would hope that you would remove the section on negligent poisoning, add poisons if you felt appropriate, and repeal those other sections, or vote the bill inexpedient to legislate. And I would be happy to take any questions.
Representative Spillane, you're recognized.
I promise to behave, Mr. Chair. Thank you. Thank you to the chair for letting me ask a question, and thank you for the member for taking my question. I appreciate you coming here to testify today. I had a lot of concerns that you've also spoken to. One concern that you did not mention is the section that only exempts veterinarians from administering medication. Do you have an opinion on that?
It was raised earlier about the ability to purchase veterinarian-like products from Tractor Supply, online, other things like that. And I do think that while we should exempt veterinarians if they were to prescribe something that didn't work appropriately for an animal, that we should make sure that the owner of the animals or owners of residences where they may bring their dogs wouldn't be considered negligently poisoning if those dogs were to get into those products.
Thank you.
Representative Marston.
Thank you, Mr. Chairman. I only have this simple question. Your association, Dog Owners of the Granite State, do they belong to or part of the Governor's Commission on Human Treatment of Animals?
Yes, we do have a representative on the committee.
Thank you.
If the chair may inquire with a question, and thank you for taking my question. If on line 15 where it says negligently on the first page, Would it change your position or the organization's position if that was changed to perhaps recklessly?
I think I would have to think about that and get the opinion from some of the other members of our group to have a better understanding of recklessly in comparison to negligently, as my background doesn't allow me to answer that on the spot. It seems similar to me. I'm not sure.
Thank you. You are excused.
Thank you.
The committee
Thank you,
now
thank you for your
calls,
testimony.
the committee now calls Kathy Farley.
Is not my printout. One of our members is unable to attend. She's housebound at this point in time and had some concerns. So I was just going to try to do some of the highlights, but a lot of it, a majority of it has already been covered. But there is a, question she had, is this bill actually promoting pet welfare, or is it just one more burden on a pet owner facing veterinarian bills as, with the poisoning? And, the ASPCA runs an animal poison hotline, and they list the top 10 poisons that that are, animals, the dogs, the cats. And, going over them, you wouldn't think of it. How many people know that grapes are poisonous to the dogs? How many people know that onions, and I've had this scenario with a friend of mine that I was showing their dogs, and he didn't think of it. They had a roast beef meal, and they put onions on top of it. So they gave him, the dog, the juice into his food. Dog ended up having seizures. And, he's still alive, the last thing I knew, but, he didn't know. And I know you'd say it's an accident, but once you know, I mean, you're not going to do it, or you try not to, but how many things? I've recently been looking at how many items include the onion, powder and things like that, and I'm like, oh, I can't give that to my dogs now, and things like that. So that's, going over the list. Your everyday person's not going to know it, and it's going to be an accident. They're not going to purposely do it, but trying to prove somebody, it's like, oh, well, your neighbor's saying you did it on purpose, and I'm like, excuse me? I love my dogs. They're my kids. And I know that's how Nancy reacts, and that's, the basis of her thing. She's writing in today in opposition to changes in the law outlined in HB 1433 relative to penalties for poisoning dogs, in particular the area of negligence when it comes to animals accidentally ingesting toxic substances. And, it turns around, and one of the things that popped in my mind when I was reading this and thinking about the poison line. Now, are they going to turn around and call the state and say this person poisoned their dog? It's like, do they have any information whether it's on purpose or not? No, they won't. They won't know. You families with kids, one's eating a grape, so they share it. And if they've got a small dog, one grape can really make that dog sick. It's, it's going to be really hard, as far as I'm concerned, to follow up and put this into play. That's my feelings. And then on my other side, when we first got into purebred dogs, we had a mutt that lived, I'll be honest, to 21 and a half years old. I don't know how she lived, because I think she was given anything and everything that we ate. But we had a Doberman, our very first Doberman, that was not even a year old. Valentine's Day, Dad gave Ma a nice big box of chocolates. it was up on the mantle. Don't ask me how she got it, but she got it down. But she was very picky. She would take a bite out and spit it out if she didn't like it. But this was also a dog that always thought you were going to poison her because she would spit out her food and then say, oh, I guess I can eat it. But I mean, you got kids that, they're eating something, they're going to give it to the dog. At least I did as a kid. So, I mean, I just, I really go along with Nancy, and I to report this as ITL or change the bill to remove the wording about negligence, because who's going to prove negligence at this point in time? So that's my say at this point. I'm sorry.
There being no questions, thank you for your testimony.
Thank you.
Is there anyone else wishing to testify who has not testified? There being none, at this point, I'm going to close the public hearing on HB 1433. How long do we got? Yeah, mine too. Someone stole mine. Wait a minute. Really? Poison dogs, 2 p.m.
At this time, we'll now open the public hearing on HB 1004, relative to penalties for failure to provide information after an animal injury. This bill was championed by Representative Hopper, who cannot be here. Is there someone that you're introducing it on behalf of Representative Hopper? You may approach. Representative, the floor is yours.
Thank you, Mr. Chair and members of the committee. I'm Keith Erf, representing Hillsborough, District 2, Ware, and Deering. I'm substituting for Representative Hopper to introduce HB 004, relative to penalties for failure to provide information after an animal injury. Ware's Police Chief Moore asked us to introduce this bill to address a problem encountered last year. In August 2021, at Clough State Park in Ware, New Hampshire, a dog bit an 11-year-old boy, causing a laceration which required 10 stitches. The owners of the dog and the parent of the child were at the scene of the incident and observed the attack. After the attack, the parent attempted to obtain the information of the owner, who refused to provide it, and then attempted to leave the scene. Police responded and were able to stop the owner. Officers issued a citation to the owner for violation of RSA 466:31, Roman numeral 2A. Dogs a menace, a nuisance, or vicious. Officers spoke to the county attorney's office at Hillsborough North in reference to the owner attempting to leave the scene, but were informed there is no requirement under existing RSAs for the owner to provide contact information after an incident involving an animal. The bill as introduced doesn't adequately address all the issues raised. Where Chief Moore wrote a proposed amendment to the bill, I asked OLS to prepare this amendment, and I hope and believe you should have this in your possession. The proposed amendment covers conduct and reporting after an incident involving an animal. It is based off the requirements already enacted by RSA 264:25, conduct and reporting after a motor vehicle accident, that was used as a reference in constructing the proposed amendment. Chief Moore of the Ware Police Department is here and signed up to speak and answer any questions the committee may have. Thank you. And I'm guessing you don't have the amendment.
I'm checking my email right now.
Okay.
But if someone wants to save me the trouble and check their email, that would be.
I last received an email from, I can give you her name.
If you have the amendment, if you don't just mind forwarding it.
If I had it, I would give it to you. She didn't send it to me. She said she would send it to the committee.
If the chair may inquire, of that,
Well, we have, he does have a copy he can make for you, but it's what I sent. So I sent both the chair and the vice chair the copy that he's referring to. That's not the version that has been written into law, which OLS prepared in sort of more legal terms.
okay.
Courtney Esbach, is that?
Yeah, you may go.
Do you want to hear from the chief in the meantime? Or do you want me to just sit here and wait?
You're excused if you wish to be.
Unless you have questions for me.
We know what we're doing, or you can finish.
No, I'm done unless you want me here.
Thank you, Representative, for your testimony.
You're very welcome. Thank you all.
At this time, the chair recognizes Officer Moore. Excuse me, Chief Moore.
Good afternoon. I was just here to answer any questions, if you had any questions about the amendment to the bill, but obviously you don't have that yet. I can read it if you'd like.
If you don't mind.
Sure. So what we did, like I said, was we mirrored this off of conduct after an accident. If a driver fails to identify themselves after an accident, and we use that same methodology to apply it to this type of incident. So we titled it Conduct and Reporting After an Incident Involving an Animal. The owner caretaker of an animal who knows or should have known that the animal has just been involved in any incident which resulted in death, personal injury, or damages to property shall immediately stop at the scene of the incident and give to any person injured and or to the owner of any property damaged the owner caretaker's name and address. If by reason of injury, absence, or removal from the place of the incident or other cause, including a fear of personal safety, to remain at the scene, such injured person, owner caretaker of the animal, or owner of the property damaged, or any of them, is unable to understand or receive the information required in this section, such information shall be given to any uniformed police officer arriving at the scene of the incident or immediately to a police officer at the nearest police station. Police officers receiving such information and other employees of such officers' law enforcement agencies shall be authorized to provide that information to such injured person, owner, caretaker, or the authorized legal representative of such injured persons, owners, or caretakers. If such owner, caretaker of the animal is physically or mentally incapable of making such report, the owner or caretaker of the animal involved in such incident or the owner caretaker's representative shall, after learning of the incident, forthwith make such report. If the owner caretaker representative fails to provide such information as required above, the owner caretaker representative shall be guilty of a misdemeanor. Whole lot in there.
Thank you for your testimony. If I may inquire with a question, and thank you for taking my question. One of the concerns that, now, I'm not sure if the amendment addressed this, but it says on line 3, if a dog is off leash and injures a person. And I guess, is there any reason to have a leash requirement in order for whether the underlying policy or the amended policy to apply?
No, sir, and that's why I took it out. So my background involves I was an officer in the K-9 unit, I was a supervisor in the K-9 unit, and I was the officer in charge of the K-9 unit. The one rule of handling any animal is that animal's under your control. A leash is not needed to demonstrate control. I could give hand and arm signals to my dog or verbal commands and still control my animal. There are various methods of control. A leash is just one such method, if that makes sense.
Thank you. And if I can inquire with another question, if a person is bit by a dog, is there any, and let's say you have the dog's information like on their collar or whatnot, what's the procedure done at that time?
So pretty much it's just exchanging information to make, we would make a police report. We could take criminal action already from established RSAs. This is just to ensure that the person bit can seek legal ramifications for the injury through civil court.
Representative Rhodes?
Thank you, Mr. Chairman. Thank you for taking my question. When this bill first came out, I actually was having conversations with Representative Hopper and Representative Erf about being a co-sponsor, but my concern was the very question that our chairman just brought up about the leash. So as you have witnessed, many of us legislators have this uncanny ability to split many hairs over wording. So is it true that the definition off leash in itself means not in control? Or does that need to change so that it doesn't say the term off leash?
So the leash component was eliminated completely from the amendment.
Okay.
As well as canine solely. You could have an incident with a horse where somebody's riding down the road, the horse bucks, it runs into a car, causes several thousand dollars worth of damage. The owner of the horse still has a responsibility to identify themselves just so they can work out some type of solution afterwards. Yes, ma'am.
Representative Pantelakis?
Thank you, Mr. Chairman. Chief, you say that they didn't have to give any information. Do they give you any information, such as the shots and things like that, when you make a report?
Are you talking about with the specific incident?
Yeah.
So Dunbarton Police actually responded to that scene, and they were able to stop the owner of the canine from leaving. She was intent on leaving without identifying herself from that scene. So we started asking the question, well, what if she did leave? And that's when we contacted the Hillsborough North County Attorney's Office and found out there were no repercussions if she did leave.
And follow-up?
You're recognized.
So shouldn't there be a penalty to her, the person leaving, because they're not saying whether those dogs had proper shots or anything?
Yes, ma'am. That's the purpose of this, pretty much. It makes it a misdemeanor if they leave the scene and they don't report to us in a very timely manner their information and that they were involved with this type of incident.
Thank you.
Representative Roy?
Thank you, Mr. Chairman. Thank you, Chief, for taking my question. I have one small question. Maybe you can put it to rest. One small concern. It says in the amendment that an officer or any employee of the department shall.
Point of order, Mr. Chair, I'm sorry.
Representative True, you recognized for your point of order?
I believe it is.
Please state your point of order.
I believe it is customary and past practice for this committee not to discuss a bill or amendment that is not before the committee. I have a real problem discussing something I know nothing about, the amendment. We should not be discussing the amendment. It doesn't exist. It's not in the committee.
I do understand. I understand what you're saying, in that you're correct. Normally, we don't really entertain, especially public testimony on an amendment unless we're in a work session, which we're not. I did allow a little bit of leeway here because the sponsor of the bill is a member of the committee who could not be here today. So I feel like if Representative Hopper was here, he would be the best person to really, I don't mean to disrespect him, he would be a great person to obviously assist the committee, but he's not here. So I did allow a little bit of extra slack with that particular rule for that reason alone. But The witness already read what the amendment would look like, but he actually said that's not what it would be word for word. And I think it's just, I understand what you're saying, but you are correct with your point of order, so I will not permit any more questions relating to the amendment that we have not received yet.
Okay, my question still stands because it's in the original bill anyway. That a member of law enforcement shall give the information to the victim of the dog bite per se. So what I'm concerned with is I see a picture of maybe a woman walking her dog down the trail. A man gets too close, maybe in an inappropriate or even criminal way. The dog bites to protect the woman. She leaves, and now this guy shows up at the police station a few hours later and says, hey, this dog bit me. Can I get her information? And now the statute says the police have to give that information. Is there any, am I reading too much into that, or?
So that type of law already exists if somebody was involved in an automobile accident. As a matter of fact, you have to give more information in an automobile accident. We made it just with name and address, so follow-up could be obtained. Otherwise, how would you know who was involved? We didn't even include phone number.
Yeah.
Representative True, you're recognized.
Thank you, Mr. Chair, and thank you for taking my question. The bill says that if a dog is off leash and injures a person, responsible, provide information. So does that mean if the dog is on leash, they don't have to provide the information?
No, sir. It results in an injury. Again, a leash does not represent control. I had multiple bites when I was in my canine unit. Some were on leash, some were off leash. It was all upon my control whether I wanted my canine to bite someone. In this case, if a canine bites someone, it's the failure to control the animal and anticipate what the dog might do, which is what happened in this case. That's the responsibility of the owner.
Representative True, you're recognized for a follow-up.
Thank you, Mr. Chair, and again, thank you. If a dog is off leash, I don't know if your definition is in our RSAs. Don't you feel a plain reading of that, minus any definition of what off-leash is in the RSA, would mean that if he's off-leash, if he's on-leash, it doesn't apply?
So we got rid of the whole leash component. There's three types of incidents that went forth in the amendment, which include if someone's injured, if someone dies from this, or if there's or if there's damage to property. So if an animal's been involved in an incident which results in death, personal injury, or damage to property are now the requirements. The control method has been eliminated. Yes, sir.
Representative Green, you are recognized.
Thank you, Mr. Chair. Thank you for taking my question. How would puppy be in relation to canine in this wording?
How would what? I'm sorry?
Puppy.
A puppy?
In other words, if somebody had a puppy that was maybe 6 months old, too early to be trained, and it bit somebody.
So again, it's all on the result of the incident, whether somebody's injured, dies, or there's property damage. It doesn't take into account the age or the ability of the animal. It's just the result of an incident.
Thank you.
Representative Spillane, you're recognized.
Thank you, and I apologize. I was running to OLS, but if this has been answered already, just tell me. What if the incident happens on my property, somebody who's not supposed to be on my property, but it's not my dog, and I refuse to tell whose dog it is?
Well, you wouldn't be an owner, a caretaker.
If I was watching my son's dog and I refused to divulge my son.
Okay, so you'd be a caretaker, so it would be applied to this. On your own property, correct.
Representative Spillane, you're recognized for a follow-up.
Thank you.
We have to run it very strict in here.
Yep, and I apologize, Mr. Chair. I apologize for being a little loose on the follow-ups. If it's on my own property and the person's not supposed to be on my own property, and I refuse to tell them my son owns the dog, I would be guilty of this crime at this point.
Yes, because you did not identify yourself. And what this is this just to get the information into the judicial system so the judicial system can take into account all the factors of what exactly happened.
Representative Muse.
So I wanted to get your input on the penalty. So the penalty in this case is a misdemeanor. A lot of our other crimes involving animals are violations. What's your opinion on that? I mean, as a police officer, one of the things we hear a lot is that officers don't pay as much attention to things that are violation level crimes. They're less worth their time. Is that the purpose for framing this as a misdemeanor level violation?
No, sir. So one thing I preach is circle of influence. I can only affect what I can affect. A violation, you're talking about a fine only. If this individual is going to not cooperate and comply with the system, and again, we're going to explain everything prior to taking action. Here's what's going to happen. Here's what's going to happen if you don't provide this information. It's going to take some effort for us to finally get that information, possibly even a search warrant. So you're talking about an enhanced effort by the police department, which was taking them away from other community concerns because someone just doesn't want to provide information where they were an owner of an animal and don't want to take the appropriate responsibility based on the actions of the animal. Yes, sir.
Thank you for your testimony.
Yes, sir.
The committee now calls Kathy Farley. You're going to wave off? Okay, the committee now calls Angela Ferrari.
Good afternoon again. Angela Ferrari, Dog Owners of the Granite State. I'm going to do the best that I can without having seen the amendment to get our concerns across so it can be taken into account or see if it has already been rectified. We oppose the bill as written, hoping to see some adjustments to it. Maybe they are in the amendment. From what I heard, I don't know that necessarily everything was. Let me give out my testimony so you can see some of our recommended changes. When you get the testimony, we had some language in red modifying what is in the current bill. One of our biggest concerns is around the use of the word injury. It's very vague. It could include something very minor. So although the amendment now doesn't focus solely on dogs, our recommended change was instead of injury to say if a dog bites a person or causes serious bodily injury to a person, that would clarify what an injury is. So it couldn't just be considered a scratch or some emotional harm from a dog that was barking aggressively at somebody, that this is actually serious bodily injury. I will mention later in my testimony, I have a link to the Maine statute. Instead of injury, they've used an injury requiring medical attention. So they've clarified that a bit further. So that could also be an appropriate alternative to just the use of the word injury. We also felt that knowingly, the word knowingly should be included in here. There could be a case where somebody's dog was off leash, out of sight, hurt somebody, returned to the person. They went along with their day, not knowing that something did happen. So we think if the person knows what happened and leaves the scene, then that would be more cause for action. The last piece that we added, and I think this was covered in the amendment, because previously it didn't mention being able to give your information to a police officer. You had to give it directly to the person who was injured. We felt that that could put some people in jeopardy or at risk, and felt that it should be to the injured person or to a police officer as soon as possible, so that they are reporting the incident and they can get their information to the police rather than necessarily handing it out to a person directly. One of the reasons for that is if this is a minor, they probably shouldn't be giving their information out to just any stranger that they've had an altercation with, and having the opportunity to get to a safe place, tell mom and dad, call the police, give them the information. It can be handled properly with an adult. The other thing, and I think this might be covered by the amendment, is if for the safety of the animal or the handler, they need to leave the scene. In a situation where dogs are in an altercation, whether it be with a human or other dogs, or what may of whoever has instigated the situation with them, to be able to remove the dog and then call the police or give your information to the injured person, I think should be considered as well. As I mentioned, Maine statute, they had a similar incident where they've recently added a new statute that hits on this exact situation. The link is here. I will email this testimony to you as well so you can find it more quickly. They do mention the requirement of medical attention. They have needing to get local law enforcement involved. And you can take a look there, but I think either the recommendations that have been proposed here addressing a few of those items, or how they've done it in Maine, would be a better option than I think the direction of the amendment even goes for this bill. And with that, I would be happy to take any questions.
The chair would inquire with a question, and thank you for your testimony and for taking my question. So one of the concerns I had when I thought the motivation of this may have been if someone's bit by a dog, they may be curious whether they should go get a rabies shot or not. And the way to figure that out would be having information about the dog. But no one's brought that up yet. I just didn't know. I understand the problems with as drafted. We can't speak of the potential of a different draft. So I guess my concern is that a concern that you have about a member of the public who's bit by a dog and how they would go about ascertaining that information?
I would defer to law enforcement, who probably could speak more quickly about the laws that are on the books in regards to dogs biting. I am pretty sure that that is why all dogs have licenses, and so that it can be looked up. And if they were able to provide their information to law enforcement, it could be confirmed the dog does have a active or up-to-date rabies and dog license to alleviate any concerns around rabies.
Thank you for your testimony.
Thank you.
This time we will now close the public hearing on House Bill 1004. At this time, the chair recognizes, this time we're now opening the public hearing on House Bill 1282 relative to the records of communication common carriers. At this time, the chair recognizes Representative Keller to introduce the Honorable. Did he resign?
Thank you, Mr. Chairman. Thank you, members of the committee. This bill may look vaguely familiar to you, as there was a bill, HB 539, which this committee and the House passed in 2001. it died in the Senate because of some language preferences by the committee. They needed some more clarification on what exactly would be the exemptions. The old bill said said that the communications shall ensure that customers are kept free from governmental intrusion into the private and personal information by requiring search warrant or judicially recognized exception to the warrant before providing information about the customer, its customers to a government entity. And that language was criticized in the hearing as far as like clarity and whether or not the communication carrier would know what a judicially recognized exception to the warrant requirement would be. And so this bill seeks to do essentially the same thing but clarify in using different language. So the new language says it shall require a valid warrant before providing a government entity with information on its customers unless it falls under the exceptions listed under our current RSA 644A3. And so that lists a bunch of things which are already in law that people already understand, and so that would provide more clarity. And so obviously the policy before this committee supported that people should not be getting be required to, the communication carrier should not be required to give out its customers' information without a search warrant being offered, just a request of the state AG's office. And so obviously requiring search warrants are kind of fundamental to our protections of people's rights. And so we definitely want to ensure that this practice of getting information without a search warrant is limited. Currently, it seems last time I did not have the information from the AG that responded to my 91A request about these requests. Specifically, since we had a constitutional amendment saying that we should be free from government intrusion into our private affairs. And in fact, what I found was that the AG office had requested, at the time of the request, at least 41 times information about customers from people from Facebook, Google, Verizon, a whole slew of different common carriers of information about their customers. And these requests generally seem to be not from the AG. They seem to be requests from local law enforcement requesting the information from the AG. So all of the information was not being, it was requested in those email, or in the demand to comply with the AG's request for information. It was not, the information only one time was sent back to the AG's office. All the information was always being sent down to some local law enforcement agency. So that is the information that I have on this, and I'd be happy to answer any questions. Thank you.
Representative True, you are recognized.
Thank you, Mr. Chair, and thank you for taking my question. And you probably covered it already, but I was not here. I don't know where I was. Do you know why they who shall not be mentioned killed the bill?
So I talked about this language as far as free from government intrusion into, requiring a search warrant or a judicially recognized exception to the search warrant. The Senate seemed, well, actually it wasn't the Senate. It was consolidated communication that said, we don't know what that is. And then the Senate also were concerned about emergency situations, like if someone's a lost hiker or something like that, that they wanted to be able to get the subscriber information of their phone or something like that. And so in this RSA 644A3, emergencies are one of the exceptions, so that would have addressed the issue. Obviously, emergencies are an exception to search warrants now, but they just wanted to have a little bit more clarity on where the exceptions were so that people could abide by the law. Thank you for the question.
Representative Tree, you have a follow-up?
Thank you, Mr. Chair, and thank you for taking my follow-up. I know that we're not in Vegas, but do you feel this new bill addresses the complaints, the whatever?
Concerns? Yes, I believe that this addresses the concerns of the lack of clarity in the previous bill that the Senate had. And so I hope that you and they will be able to support it. Thank you.
Thank you.
Thank you for your testimony.
Thank you.
The witness is excused.
The committee now calls Senior Assistant Attorney General Ben Agati from the Department of Justice.
Thank you very much, and good afternoon, everyone. I'm here from the Department of Justice. Again, my name is Benjamin Agati. I'm a Senior Assistant Attorney General in the Criminal Justice Bureau. Our office is not taking a position with regards to this bill at this time, but we wanted to make sure that we were present so we could answer any questions that anyone in the committee may have. I've had an opportunity to look at the bill for a little bit, do a little bit of background research, and I just stand here ready to answer any questions anyone may have.
Representative Marston.
Thank you, Mr. Chairman. This goes to the point I'm glad you're here. As I understand it, the reason for this bill is because lower levels law enforcements do not have the knowledge that they need to get a warrant to do some of these inquiries, and they're just doing it without a warrant, which is violations. Your mic.
My apologies. Is that better? I'm sorry about that. I don't know if that they should know, certainly, that any time that you are seeking to get content of an individual's account record, and so now we're talking about, again, actual content of somebody's accounts or records, then they certainly should be getting a search warrant, and that's the current standard now that all law enforcement operates. The vast majority of the requests that we get are primarily from New Hampshire's Internet Crimes Against Children Task Force. I'd probably say 60 to 70% of the ones that we do. And a former speaker representative was absolutely correct in terms of between 2018 and 2021, I believe from January's of those dates, I believe we did around 41 to 43 of those requests. Again, about 60 to 70% are Internet Crimes Against Children. There's a smaller majority that are drug cases, and quite frankly, I really don't have any personal knowledge of any other cases. But it's usually a 7.6b subpoena that, when it is issued, inevitably leads to the search warrant being issued, because you can't get content with a 7.6b. All you can do is identify the individual name that is attached to that particular account, or the individual phone number that's attached to that account. The vast majority, and pardon me just for a second, I know it can be long-winded and I apologize, but to explain how most of those cases come in, it's even a process people in my office, not in the criminal bureau, are not familiar with. Often we will get a cyber tip that will come in, and that will go to the ICAC task force. And then that goes to one of the local catchment agencies that has an ICAC officer assigned. They then contact us if they feel that there is reasonable belief to believe that you have the communications common carrier is being used in the commission of, or about to be, or was in a crime. And they will ask for our assistance for a 7.6b subpoena to find out who is registered as the owner of this IP address. And that's, I mean, it's very clear in the statute, it's a very limited information that's available. That then leads them to develop the case to either find that somebody may be in fact guilty or innocent and lead to a search warrant. The only case that I can think of myself that I've done, I've been here for about 17 years, has only been one that was involved with a homicide case, and it turns out that when we did the 76B subpoena, we were able to show that the individual IP address was somebody that didn't have a protected Wi-Fi. There were 20 or 30 other residents in the building that could have all been using their signal, so it was used really to exonerate an individual rather than find that they're guilty. To directly address the question, I think that law enforcement should certainly know that if you want any sort of content, you have to get a search warrant. That's the law as it stands right now. 76Bs are primarily used as a tool to get the investigation started, to just say, are we looking in the right area without going into an individual's content.
Thank you.
Thank you for testifying. The chair can inquire of a question.
Certainly.
Thank you for taking my question. You mentioned that the term reasonable suspicion, and I presume where it says a valid search warrant, that doesn't say it, but it's referring to probable cause. Can you explain, I guess, what would happen if that standard was a probable cause requirement as opposed to reasonable suspicion? That changed ICAC's ability? How much would that change in the real world?
In the practical sense, the court does draw a distinction between reasonable suspicion and probable cause. And that's been standard both when you look at this from a federal constitutional rights that we all have or the rights that we have under the New Hampshire Constitution. So the court does draw some distinction, but what's great about many judicial decisions is, of course, it doesn't say exactly what that distinction is. So you're still looking at it being whether it is more reasonable or not, or the court will say, is it more probable none? And each time, the court will always say, we will use a totality of the circumstances test. We will look at all of the circumstances when we know and find whether it's, again, either more reasonable or more probable. But better that I can't really define what that standard is better than that because the court won't define what that standard is better than that.
Representative Muse?
Thank you for taking my question. As a practical matter, when it comes to these investigations, to what extent would it be an additional burden on the Attorney General's office to have to go through a process of securing a warrant for this type of information? Is this not a big deal? Are there time issues involved? Is there a problem?
I would answer that by saying that there are certainly some time issues that are naturally going to be involved in that process. To give everybody kind of an understanding of what time issues look like now, when one of those cyber tips comes in and it gets to the right investigator who then says, this could have grounds for a 76B, let's find out who this IP address is. That phone call can be made and we can probably, after we review it, because again, there does have to be that reasonable suspicion that it's there, and we have to check that before we even think about writing one of these up. You're looking at a process that may take an hour or two. A search warrant process is naturally going to be a little bit longer. You have to be able to submit the search warrant. You're also going to have to, it also depends on the time of day. An assistant attorney general is usually available 24/7 for law enforcement. All they have to do is usually call one of our cell phones in order to do a search warrant instead. If it's daytime in Superior Court, where most of these offenses, crimes against children, child pornography, drug offenses, most of those are felonies, so they have to be in Superior Court. That's pulling a judge off the bench to be able to make that decision, or trying to get the nighttime judge. You have less control over what the timeline of that would be. And with most of the ICAC references that we get, there's a question of whether or not there's a child that is currently or in the immediate past in danger. And that's one of the other reasons why, when you ask about delay, there would be some delay that would come in with regards to doing a search warrant. But again, it would not have content, so you can't get any content with these.
Representative Muse, recognized for a follow-up.
Just a quick follow-up. In cases like this, how important is it to act quickly versus acting with confidence that you're basically dotting all the I's and crossing all the T's?
I would say the second one is more important. It's crossing the T's, or dotting the I's and crossing the T's that's more important. There has to be, for example, one of these comes in, each one of us in our office writes up a memo that's kept in-house. that understands what the facts were for us to have a basis to be able to issue this letter. I think one thing that many people don't understand about prosecutors, whether it's in our office or countywide, is to say we actually say no a lot more than we say yes. And here, it's more important to make sure that you have it right, just as much as finding the guilty, protecting the innocent. Having it right is more important than expediency.
One final follow-up. And would you say that having a warrant in this situation would help you do that more effectively?
I think having a warrant in this situation, it depends on the material that we have. I think here you have a standard that, yes, you're looking at here for reasonable suspicion that the communications common carrier has been used in the commission of a crime. It's often, most of these will lead to a warrant once you're seeking an individual's content. It has to be that way. It's the right thing to do in that case. But in that balance of time and crossing the T's and dotting the I's, having the appropriate medium between meeting both of those needs, 76Bs currently tends to do that, but certainly when it comes to the ICAC cases.
Thank you.
Representative Newman, you recognized.
Thank you. You may have mentioned this in your testimony. I haven't picked it up or understood it completely. The way this law is written, it repeals a section and then reenacts it as written, and it makes it very difficult to understand the difference between the reenacted language and the language that was appealed. Could you just briefly comment on what effect this has as a replacement? Thank you.
Certainly. I'm sorry, let me just make sure I have the statute with me. Essentially, if you look at the two side by side, you can read through subsections. I believe we're looking at Roman 1. Sections A through F are identical between the two statutes. So essentially, it takes the current law of what's in place that would allow this written administrative subpoena process, and it stops that, it ceases it. And so for those same sets of information that currently an administrative subpoena would be available for, now it must be done via search warrant under what's proposed.
Representative Newman, you recognized.
Not knowing the difference between a search warrant and an administrative warrant, is one simpler, one easier, one more effective, one less effective, or what? Do you have any comments about that?
Sure. An administrative warrant, when it's issued from our office, is very, very simple. It's a document that would come out, let's say, on letterhead. It would be signed by an authorized and trained assistant attorney general. There is a training process that they have to go through. Not just every attorney in my office has the ability to issue these. They have to know, again, what they're looking for, be able to appropriately write the in-house memo and say that they can find that reasonable suspicion is there. The process of issuing that, it looks almost like a letter. It puts the statute in it, and so that the receiving company understands what it is. A search warrant, on the other hand, you're going to require a submission of an affidavit that has to get written by the investigator, not by an attorney. That then needs to be submitted to the court. There is a whole process to do that, both in the district and superior court, usually with an application that comes in, potentially also with the motion to seal with regards to the nature of the investigation. And then that has to get approved by the court. They will issue the warrant. It's a one-page document that comes out, signed and certified, and then eventually a return has to be filed with the court. So an administrative subpoena is essentially a two-page document that would come out of our office, looks a lot like a letter. A warrant itself would involve a submission of a multiple-page affidavit to the court, a warrant application, a warrant that issues, and then a return that has to get filed back with the court once the company provides the information. I hope that answers the question.
Representative Newman, recognized for a follow-up.
Thank you for the follow-up. So those two things, they both have the same, do they both have the same effect, that you can start your investigation and get the same type of information as a result of either one of those right now? Well, not right now because this isn't enacted yet.
Mm-hmm. So I just want to make sure if I can clarify that I'm understanding the question correctly. so that can the same information be obtained under the current standard versus the proposed change?
Go ahead. Thank you. Yeah, you gave a description about what you get from using this with the search warrant, and you could start an investigation, and you explained a lot of things to it. With an administrative warrant, could you also get that same information, or is it less information you get, or more information? Is there what's the difference between the two?
I understand. There's a very large difference between what's available now under the statute versus if you were to choose to do a search warrant right now. If you were to choose to do a search warrant, for example, and I did bring an example with me, a matter that was submitted to our office just last in September, where Facebook alerted us that there were 2 images of underage children that they believed violated child pornography laws here in New Hampshire. For us, once that cyber tip comes in, we could now, under the statute as it is written, do an administrative subpoena to find out the registered name or the email address that goes along with that Facebook page. And then the investigation could start from there. And we would be very limited in what we were able to find out. We would be able to find out specifically the email address that they've used to create that account, a phone number that they used to create that account, and that is essentially it. If it was a phone number reporting, we could find out the name of the person that owns the phone number or the IP address. That's all that's really available under the current 76B. If we were to do a search warrant right now for that, let's say that would allow us to now obtain copies of everything that's in that person's Facebook account, look at the photos, look at their text messages, look at their posts potentially, as long as it's reasonably tied to what we believe is the infraction that's occurred, the crime that's occurred. If you were to seek to get into the Facebook, and we believe these 2 photos are there, a search warrant would allow us to go in, look at the Facebook, see if those 2 photos are there, and find out discussions back and forth about those photos. We couldn't willy-nilly grab everything that's there. That wouldn't be proper because we don't have probable cause to believe that the other things on that page are evidence of a crime. We can only go in and get what's evidence of a crime. But we could not get any sort of content, we can't right now, under the 76B law as it's written, only to find out who the individual is, and then that would have to lead to more investigation to possibly get a search warrant, which many of them do.
Thank you.
Representative True, you recognized. Thank you, Mr. Chair. Thank you for taking my question. With the bill becoming law, I assume that the communications carrier is not liable for giving the AG my personal information. What if a local law enforcement agency called up and said, "Hey, Zucky, it's your old roommate. Can you give me the information?" And they give them my information, my name. No, not me, him. My name, my address. They give all this stuff out because he was calling in a favor or whatever. What's the penalty for them doing that?
So in an action like that, and I can only speak to it from my own standpoint of being a prosecutor. So if that case were to come to me and I find out that the local law enforcement officer did not properly assuming that this change were to go through, if you choose to do that, and they did not get a search warrant for it, most likely what that means is that any evidence that was gathered as a result of that, the information that he learned, and the fruit of the poisonous tree doctrine, which would be any information he learns from that information, would be suppressed. We would not be able to use that at trial.
Representative True, you're recognized for a follow-up. Thank you, Mr. Chair. Thank you again. Yes. So, but I can't say my good name is besmirched because I've been charged with a horrible crime. But that information is now out in my town. That's the guy. They didn't do anything to him, but everyone knows I'm the guy. Would you bring a communications company to court? Would I have to sue?
Oh, I see. You mean for for if there wasn't a protection that was written into the statute. Whether or not that is something that the AG's office would pursue, unfortunately, that's going to be something outside of my bailiwick. That's going to be upstairs in the Civil Bureau. That's going to be much better able to answer that. As I frequently say to a lot of victims' families that I might work with, there's always a difference between I don't know and I can't tell you, and this is an answer, well, I don't know. That would have to be a decision probably made by the Civil Bureau.
Thank you.
Representative Muse?
Thank you. Thanks for taking my question again. So to basically try to sum up part of this conversation, and I want to make sure I'm summing it up accurately, but the current process is for you to obtain an administrative warrant, which is fairly easy for your office to do, fairly easy for your office to get. A search warrant, though, would have a much wider scope. So one of the things that occurs to me, and I'd appreciate you just letting me know if this is true or not, because a search warrant has a much wider scope, there's potential for a lot more personal information to be found and disclosed through that process, correct?
That's correct. The 76B, as it's written, and when I say as it's written, or if you choose to adopt this, when we're looking at that subsections A through F, those pieces of information are what we would consider very, very simple business records that a person has chosen to sign up with Facebook or chosen to sign up with Verizon and have service. That is, again, very basic business record information. No real private information and no content is available through the 76B process as it's written now, and it would change. To get that stuff now, you have to go through a search warrant. And if this change were enacted, that would still be true. You would still have to go and get through a search warrant. So, for example, and I think this might best answer the questions, things that are not available under a 76B right now, you would not be able to find out when a person logged onto or off of a service. You would not be able to find out the websites that they visited using that service. You couldn't find out who they emailed. You could not find out who emailed them. You couldn't find any sort of content of their communications. None of that is available through the 76B process right now. The only way to get that is through a subpoena. If you make this particular change, that still will be true. You will still have to get, search warrant. You will still have to get a search warrant to get that content.
Thank you.
Representative Newman.
And just one final question about administrative versus search warrants.
Yes, sir.
If this bill passes as written, will you still have the capability that you have in the current law that says upon written demand of the attorney, et cetera, et cetera, et cetera? Will both of those things be available to you, or would this require that they all be done by search warrants?
As I am reading through this proposal, effectively what it would mean is that this same information that is currently, again, 16 to 18 times a year that are used through an administrative subpoena would now be required to have a search warrant done instead. And so law enforcement would have to seek a search warrant for that same information.
Thank you.
Representative Spillane.
Thank you. Thank you for taking my question. If I'm understanding this appropriately, the extent of information you can get off an administrative request right now is extremely limited.
Absolutely.
You can essentially tell that somebody used a service and what IP they used it from.
That's correct.
You can't tell any of the other information that they've done over that service, when they've logged in or out, any of the other information. If you've determined that they've used the service, you would need to now get a search warrant to find the specific information that you think was negligent or criminal in their use of the service. Is that correct?
That's absolutely correct.
So in essence, follow up? Thank you. I'm sorry for slacking on that again. In essence, all this bill would be doing is taking out the preliminary step where you've verify that the person used the service and had an IP address that came from their computer?
Yes.
Because
that-
you would have to go directly to the warrant process.
You would have to go directly to the warrant process. What it would do, it would change the method in which that information was gathered. Instead of phone call and establishment and the issuance of an administrative 76B subpoena, you would go through a warrant process instead, and you would have to do that in order to obtain that same information. That's correct.
Thank you.
Thank you for your testimony.
No problem. Thank you.
The public hearing on HB 1282 is now closed, and we will be executing some bills. So 5-minute recess.
We were hunting for my bottle. Yeah.
Next time, Laura, just push the chair back and say, David, get that.
Yes, yes.
Your mask is hanging up here. I don't know.
Yeah,
There you go.
Oh, I got one thing. Another.
We needed some excitement after that.
We can have excitement, but I don't want it to be me. I know.
came once a week to the house for 2.
At this time, I'm gonna go very slow. Here. At this time, we're now opening the executive session on House Bill 1571, increasing fines for littering and directing revenues to the Fish and Game Department. This time, the chair recognizes Representative Conley to make a motion.
I would move ITL on HB 1571.
Motion of NXP into legislate. Is there a second? That has been seconded by Representative Burt. You wish to speak? Representative Burt?
It's a bad bill. Well said.
Representative Lang?
As the chairman of the Fish and Game Committee, I agree, it's a bad bill.
Representative Marston, you wish to add anything to that discussion?
Yes. I have a question, if I may.
You may speak.
You heard all the testimony, and I was unfortunate not to be here. I had originally thought this bill should be an ought to pass in my note-taking at home. I'm just wondering, why are you people thinking this is a bad bill? I mean, it gives revenue to the Fish and Game, and it also increases the fines for people littering. And to me, that kind of makes some sense. So where is the problem in this bill for me to vote with you?
I'll start with answering that by I was also not here for the hearing, so I didn't hear the testimony that was presented to the committee. But from what I understand, this would have a cost of $75,000. It's not clear that the fines would actually account for that revenue. But it also has been brought to my attention that there is another bill that's in the Transportation Committee that addresses littering that may find its way to this committee that's a little less of a fiscal impact as this version. So that's just my own opinion. But I wasn't here for the hearing, so I can't help.
Thank you for that explanation. May I do a follow-up to the gentleman from Fish and Game? An explanation as to why it's a bad bill?
Sure, absolutely. So again, while Fish and Game is a self-funding agency, this starts drawing from other areas of our citizens that hasn't been vetted yet. So for lack of a better phrase, we're starting to add. We'll use the example of a $500 fine, which has a 20% penalty assessment, which makes it the $600 fine, which then another 20% penalty assessment for Fish and Game, which now makes it a $600 or $720 fine. So I think it's poorly thought out. The whole idea of 20% is a number that no one's quite sure what it means.
Thank you, Tim. Representative.
Representative Wallace?
Thank you, Mr. Chairman. Also, Attorney Head from the Department of Justice said this is going to net about $5,000 a year in new revenue. And with a $75,000 implementation cost, that's a net negative of $69,000. That's a big no.
In 15 years, it would take to recover that. At this time, the matter will now be put to question. If you are in support of the motion of inexpedient to legislate, please say yes. If you are opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy.
Yes.
Representative Lang.
Yes.
Representative Burt.
Yes.
Representative Rhodes.
Yes.
Representative Green.
Yes.
Clerk votes yes. Representative Spillane.
Yes.
Representative True.
Yay.
Representative Pratt.
Yes.
Representative Marston.
Yes.
Representative Harriet Gathright. Representative Pantelakis.
Yes.
Representative Tulersky.
Yes.
Representative Bourdonnais.
Yes.
Representative Muse.
Yes.
Representative Ray Newman.
Yes.
Representative Bolden. Representative Conley.
Yes.
Representative Sue Newman.
Yes.
Representative Bradley.
Yes.
Chairman Abbas.
The chair votes yes.
And one not voting. 20-0.
I move for consent.
So moved. Representative Conley, will you be preparing the majority report? Thank you. At this time, the executive session, we'll now close the executive session, House Bill 1571. At this time, we'll now open the executive session on House Bill 1175 relative to recording interactions with public officials. The chair recognizes Representative Bradley to make a motion.
Thank you, Chair. I make a motion to ITL HB 1175.
That's been seconded by Representative Pantelakis. Representative Bradley, do you wish to speak to your motion?
I do. I think earlier Representative Rhodes said it better than I think any of us could. She addressed the seriousness of being able to videotape inside a public school where parents at this time do have a choice of whether to opt out their children from photographs or videos. And this just will put those children and many other children at risk.
Representative Rhodes?
Thank you, Mr. Chairman. I think that this bill as written has several gross unintended consequences. And while I do recognize that people have the right to record public employees, I also recognize the right that public employees have a right to privacy. So there was testimony given today that if you are in a room that is labeled private, but yet you are, let's say, a boss of an organization that's a public entity, if another employee is in that room having a conversation, what if this conversation involves the employee's health? What if they need to take a family time leave for a private matter? That is an unintended consequence of this bill. Furthermore, we had discussion about recording in schools. So what I fear is going to happen next is we're going to have a law that says, well, now they lawfully need access to the school because they're allowed to record these teachers, and that is where we're getting into the issue with kids. I'm able to protect myself. I will protect myself. But when you start talking about my child or somebody else's child, that is off limits. Thank you, Mr. Chairman.
Representative Roy?
Thank you, Mr. Chairman. I actually was a co-sponsor of this bill, and I was for it until the witness testimony, and they talked me out of it. So I support the ITL.
Thank you.
Now, I have to apologize, I also was not here for this hearing. Was that witness in support of this bill or in opposition?
The witness was in support of the bill.
That's interesting to know. Representative True.
Thank you, Mr. Chair. Government must be open and accessible. Students are not part of government, but teachers and coaches and zoning board members and planning board members who aren't paid, they're part of government. Recording public officials doing their public job, there's nothing to be hidden from the public there, because the Constitution says government must be open and accountable to the people. So I can't support the ITL. Thank you, Mr. Chair.
Representative Marston.
Thank you, Mr. Chairman. I, too, was not here for the hearing, and I originally was saying maybe ought to pass in my notes. I guess I'm somewhat with Chris True, Representative True, in that we need to know, and there shouldn't be any reason why somebody shouldn't be recorded in their official capacity. I understand that politicians have a right to privacy, but not a right to privacy when they're doing their official business. And I don't know, but do we now have a situation where you can record officials, like policemen and stuff?
So the courts have ruled on this rather consistently, that any public official is, for the most part, I mean, there's time, place, and manner restrictions, but you can record a police officer who's acting within their official capacity. As long as you don't obstruct what they're doing, you're free to, that's a First Amendment and even in some circumstances a Fourth Amendment issue. So you're allowed to do that already. This was making an attempt to codify basically, different Supreme Court cases from all different states and the Supreme Court of the United States. I think the concern that was brought up, and someone who was here, please correct me if I'm wrong, is that an individual with perhaps a known criminal background can go on school property, and because a teacher can be considered a public official because they're an employee of government, could be recorded by this individual with the criminal record, and that crime can even involve crimes against children. But nonetheless, they can do, under this, if they're going to say, well, I have a First Amendment right to do this, I want to record the teacher. Oh, it just happens to be an elementary school classroom. I'm just explaining in that scenario, that's the concern of some of the unintended consequences. If you're in a public space, if someone's in here, a member of the public, and they start recording us, they're allowed to. Even, and I hope this doesn't start happening, but if I'm at a restaurant even, what am I going to do? My protection is not the First Amendment, it's the restaurant to help me out and say, hey, can you have them stop? But as a public figure, we sign off on that. But a teacher teaching a classroom who's trying to educate children, having that scenario arise, it's a concern, and I think the bill's well intended. I certainly don't think that was the intent of the sponsors who put the bill forward, but unintended consequences it may have. Representative Marston.
Thank you again, Mr. Chairman. The example, as I understand it, is a criminal going into a classroom. Most schools are secure. You have to be buzzed in. You have to have a reason for being there. You got to see, you get stopped. You just don't walk in like you did 20, 30 years ago. So, and again, a criminal going to do this? I don't think they got the brains to figure out to do that. But again, I'm along with Chris True, Representative True, and I think this bill ought to pass, and I will vote against the ITL. Thank you.
Representative Burt.
Thank you, Mr. Chairman. I, too, will be supporting the bill. I have supported this for many years. I've talked to the ACLU about putting in a bill to do away even with one consent party, because the states that don't have it, which are the majority of the states, there's only a few states that are like us where you have to have two consent. And it's easier to catch, the town worker, the state worker that's misbehaving, or an elected official, with the video and audio of a recording of their misdoings. I just look at, the government must be recorded at all times. If I had my way about it, every one of them would wear a body cam, and then we'd have access to that body cam. Now, when they're off duty, absolutely, they have a right to privacy. But if they're at a grocery store, that's a public place. Anybody can come up and film me. People have taken pictures of me at stores. Not often, but a few. And, I just was hoping it was because of my looks. But, bottom line, people can do in public, they still can do this. And when it comes to schools, I mean, I think people are just looking way too much into that. I don't see how that can happen out of this bill. Because bottom line, a classroom is a private classroom with those students and the teacher, and I don't see how this bill would allow somebody to say, I have a right to go in there. Now, if it's a parent talking to the teacher, after school, absolutely, that parent has the right to videotape that. And, it's just, eventually we'll get there, but we have to pass something, and sadly it doesn't look like this is going to be the bill, so hopefully at some point, they'll redefine, what is allowed. But, right now, throughout the courts, we can finally videotape police. And I know in Ware they arrested 6 people for videotaping their own traffic stop with the police, and luckily it ended up down into a federal court in Massachusetts. And, because all of our courts kept saying, yeah, you can charge them for wiretapping. And finally the court down there said you can't. So that's all this bill was going to do, was to codify what the federal court already says we have a right to do. And so hopefully they will keep pushing toward it. Thank you.
Representative Newman?
Thank you, Mr. Chair. I'm going to support the ITL. And the primary reason is just the way the law is, or the proposed law is written. And especially because of the confusion over definitions of things like in public. What exactly does that mean? And so it seems to me that with the public, you can have a public building, but there are private spaces in that public building. After the hearing, I talked to one of the people who testified, and what I heard and I agreed with was that a public space is probably where the people can come in and out of here and go as they please. In a school, they can't go in and out of there as they please. But that's not defined this way so that people can easily understand what this will be. So I think an amendment might be able to improve this bill. I don't know. But for right now, the way it's written now, I'll support an ITL.
Representative Pantelakis?
That this bill is too far-reaching. And we have boards that are water boards or recreational boards that are considered as officials in that area, and that they would be able to be recorded when they might not even know that this law exists. I mean, I just don't think that this world has gone so far that every time somebody speaks, they have to be recorded. Thank you.
Representative Muse?
I do want to say that I'm very sympathetic with the people who put the bill forward, because I do think that as public officials we have an obligation to be transparent and to be cooperative when constituents or anybody else asks us questions about what we're doing. But the issue I have is how we define public officials. So are we defining public officials as people who are elected to office or appointed to office? Do they include every classified employee who works for any government agent, it works for government really at any level at all? and separating, you know, well, in an age when a lot of people are working virtually and a lot of people are working at home and not everybody goes to an office, it becomes very, very difficult to sort of separate, you know, what your work life is from your personal life. And I think that if we pass this as written, one of the things that we're doing is in an effort to create more transparency, we're really opening the doors to some really, really critical violations of privacy, and also just people's well-being. Who needs to be followed around with a camera? Who needs to worry about having to shut the blinds of their house? I mean, that one guy was testified the only time we shouldn't be available to people is like when we're in our homes and when we have the blinds closed. I mean, you know, so I mean, that gives you an idea how some people might interpret something like this, and I think that's why I'm going to vote for the ITL.
Representative Roy?
Thank you. As I said earlier, I was one of the sponsors, and I believe that there is absolutely room where some recording of public officials can happen and should happen, and people should be able to do. But I also want us to look at the humanity of it. Right now, I go to the landfill every Saturday. One of the guys at the landfill, I love chatting with him. I almost said shooting something. Chatting with him, and he'll give me some of the local gossip, and it's just one of the places you go and you hang out and you talk, and he's good. Well, I don't want people like that to worry that every time they talk to someone, they have to, we're all going to turn into robots. We're going to give the minimal answers. We're not going to engage on a personal level with our constituents, because you never know who's recording you, who's trying to trap you. I mean, it's going to turn us all into a bunch of robots. Now, there's some, like I said, there's some situations, such as with law enforcement, or if you walk into an official's office and it's already an official interaction. But when you can be recorded at any time or place and it turns into a game of gotcha and you just can't be friends with your constituents anymore or friendly with people you don't know, it's just not a world I want to live in. So I wouldn't support something so broad.
Representative Bourdonnais?
Thank you, Mr. Chair. I'm going to support the ITO motion. On first reading of the bill, it seems to be a good bill, something that we could all support. We all believe in the public needs to have access to public meetings. But unfortunately, the way this bill is written and could be interpreted, there are ramifications that we don't know exactly what it is. And so it's a little broader than we need. What I would suggest is the sponsors of this bill take a much narrower view of what should be recorded. And I think public meetings are probably the place to start. Right now, I don't think we have legislation that allows all public meetings to be recorded. Though in this day and age, it seems like all our public meetings are being broadcast. And we also maybe want to look at making certain that our citizens and our law enforcement people understand that any interactions of them with the public as far as traffic stops are recordable. And I would be more than willing to support such legislation in the future, but I am really opposed to this particular bill. Thank you.
Representative Eric Arthright?
While we were in that meeting, Bradley did research because we were concerned about what was public place. And in the statute, it says that any place to which the public or a substantial group has access. The term includes but is not limited to public ways, sidewalks, schools, hospitals, government offices or facilities, and the lobbies or hallways of apartment buildings, dormitories, hotels, or motels. He also said, please note that this definition was found in RSA 644:2, which addresses disorderly conduct. I think I was appalled when I think it was I don't know what town he's from, but one of the representatives said that if I was in a restaurant with my son or my child, and I was talking politics to them and someone is recording me, I don't think I would have felt comfortable about that. And it really did hit home because quite often I'm with my grandchildren and therefore always asking questions. And I'm always talking about what happens, you know? So for me, I think that's an overreach into my private life, especially, and if it didn't matter whether I was off duty at that point because I'm not doing state business. Right, at that point, I'm on my own time with my grandchild or my children. So with all that said, ITL.
Representative Splain?
Thank you, Mr. Chair. I liked the concept of this bill. I liked the ability for a family, specifically because of the research I've done into the DCYF situation, a family that had a DCYF person coming in for an interview to be able to record that person in the process of their job inside their own home. But I had a problem with the fact that it said in public because their home is not public. There's a problem with the bill in that aspect. I think that, yes, we should be able to record police officers in the course of their duty when they're in public, arresting people, or even if they're in your private home, you have a right to record them in the process of their duties. But like others, I feel that there's a great expansion here of what is intended. And I would have rather seen this bill go to interim study to fix it, but I'll support the ITL if that's the way the committee is going, because I think that there's a future for this and there's a need for this, especially with the situations we've seen, with the need to record police and DCYF and other things. But at this point, this bill is not ready.
Representative True?
Thank you, Mr. Chair. This is probably just a question of the chair, or just a clarification of what I believe I heard you say in giving your opinion earlier, that the Supreme Court has already stated public officials during the performance of their duties may be recorded, and that the Supreme Court did not have any difficulty understanding what public officials meant, nor did they have any difficulty in deciding what performance of their duties meant. And with that, all this bill does is put into New Hampshire law what the Supreme Court has ruled in cases.
I think that's an oversimplification of what I was trying to say. But no one, right now under current law, the representatives, using the example, if you're in the privacy of your own home, can you record someone? If you have a home security system, as long as you post a notice, that's how you get consent. If you look at it, RSA 570A:2, a lot of that has to do with the two-party consent and whether the other party is okay with being recorded. And then there's exceptions to when you don't need that person's consent. Being a public official in a public place, you do have a right to record the person, but when you have a First Amendment right, you can't just say whatever you want. There's certain things that are definition of speech. From what I understand, that this is being interpreted too broadly, where there is no exception. You would be allowed to record a public official, provide they're on any type of public place without any exception whatsoever. So this is taking what I would say the Supreme Court ruled and even expanding that. And I think what it's expanding it to is what are some of the unintended consequences that a lot of the members had concerns with. If someone is here filming us, it's their right. And under the First Amendment, they're allowed to do it. And no one would argue otherwise. But by codifying this, and keep in mind, the Supreme Court of the United States makes a decision, but we, and Representative Harriet Gathright read this, as at the state level have a definition of public officials and public property. So that's where the language, we can mix and match the words and create confusion. That's why the unintended consequences is what a lot of the concern people have with the bill. At least my concern is. You may respond to whatever
And pre-med, not pre-law, but could you give us the Supreme Court case where they stated that public officials may be recorded during the performance of their duties so that we could have a chance to read that Supreme Court ruling?
Off the top of my head, I can't, but it involved the similar law in Massachusetts where a student was filming police officers arrest her friend, and she was also then got in trouble apparently for recording the police officers. And the argument was, well, she didn't have our consent to record us, and the Supreme Court said, no, you were in public, you're a police officer, you were performing an arrest, she had a First Amendment right to record that, because what she believed was sincerely a Fourth Amendment violation, an unlawful arrest. Regardless of whether the arrest was lawful, as the court said in that scenario, they said as applied in that circumstance, that was unconstitutional because she had a right to record. That's not a New Hampshire law.
I thank you for that. Maybe a rough idea of the year, so I'd have a chance of finding it?
I think it's 2012, if my memory's correct.
So I'm
Thank you,
pretty
Mr.
sure it's someone you know, Chris. It's Carla Gerlich's case when she was recording the Ware police officers, I believe it was. So it's someone you even know. You can go have a conversation with her. She took it all the way to the Supreme Court because she was charged with wiretapping. And then she ended up taking it all the way to the Supreme Court, and the Supreme Court ruled that you have the right to film a police officer in the performance of his duties, and you don't need their consent because they're in the actions of doing their public job. If I could just one more thing, Mr. Thank you. So the second thing I'd say, Chris, is when are you off duty? When are you off duty as a state representative? When is a police officer off duty? Right?
I'd say a police officer off duty when he's off shift. The police officer goes back on duty if he's going to claim the right as a police officer to stop a crime. Now he's acting as in his official capacity.
If I may,
He's
Mr.
not
Chair?
on the clock there, but he just became an official representative of the police.
So the unfortunate thing is, a police officer, you're on duty 24 hours a day. You have the authority and the responsibility to act. And so you have, almost in any circumstance of this law to go in effect, you have no privacy anywhere you go. Because a police officer has that authority, and they have an obligation to act. So again, I think this law is a little bit too broad, a little bit too vague. Again, I go back to the conversation, when are you off duty? How many conversations you have about politics when you're at home, you're in a restaurant, you're in a grocery store, someone comes up and says, hey, what happened to this bill? And the question is, do you want a camera in your face every time you're just having a private conversation with a citizen about updating them on whatever the information was? Do you want a camera in your face? I think that's, it causes problems.
And to not over confuse the issue, when we say public officials, if you're a public figure, a celebrity, an actress, or a famous author, they go out in public and they're constantly confronted by other members of the public who want to take a picture with them, or the paparazzi follows them around, and even that's protected by the First Amendment when they're sitting in a restaurant just having a cup of coffee, and then all of a sudden people just start taking their pictures. So celebrities go through the same thing as well. But we're talking about kids in a classroom here and a teacher teaching a class, and all the concern is that the bill as drafted would go too far. No one's trying to trample the First Amendment here. It's just,
I don't think that's a fair interpretation, because as been mentioned before, you can say, I want to protect my children, but the school protects your children by not allowing you to walk into the school. You can't say, well, those kids were being filmed by this, whoever he was, this Mr. Unknown. What, did the principal just buzz through? Go walk around all you want. That doesn't happen. So it's an unfair characterization that it's about the students when that can't happen.
Representative Marston.
Thank you, Mr. Chairman. I just want to point out to the committee, it specifically says when you are in the process of performing his or her duties. When you're in a restaurant, you're not performing your duties, you're feeding your belly, and you are not to be then recorded. But I don't understand why you have such a problem. There's a time and a place to record officials doing their official duties, such as the police arresting somebody or so on and so forth. There are times and places when we should not be allowing somebody to photograph or take videos of you when you're in a restaurant or when you're with your family out shopping. That's ludicrous. Who's doing that? I just want to point out.
I just wanted to remind the committee I wasn't here for the public hearing, so. So if someone wants to summarize what was perhaps said in a short, concise. Representative Roy, you were at the time acting as chair of the committee. Perhaps you would like to summarize the concerning.
The sponsor of the bill was entirely reasonable. The supporter of the bill was not quite so much. And he was here recording us as he did it, which is his right. But when explaining what he would do with the bill, he would record.
What did he say he would do?
Yes.
Sorry, he said that he would remove the section where it says, in the process of performing his or her duties, it should be done at any time and anywhere.
Yeah.
I'm telling you what he was recommending an amendment for. Sorry.
Yeah. And there wasn't, to clarify the school issue, there was never any talk about adults being able to walk into schools. What the discussion was a student in the school wanting to videotape their teacher. And, well, in the process of doing that, if the kid is 5 rows back, he's going to catch the first 5 rows of other students in that recording whose parents have not given permission. And his response to that was, well, if you don't like that, take your kid to a private school. And that's just entirely inappropriate. What good does it have a policy in the school where you cannot take images of students without the parents' permission to just let anyone take videos and put it out on the internet for anyone to see? And someone advocating for that, frankly, with a criminal record of inappropriate conduct with children is just beyond the pale. Having said that, I still think there is reasonable ground to be had in it, but this is not the vehicle to do it.
So just to summarize that testimony that I was not here for, is it fair to say that if a teacher was with their classroom on a field trip on some nature trail somewhere in a public place, that individual, although recording the teacher may inadvertently record the students as well, would be within their grounds to do so?
Yes, if the teacher is taking the kids to a public park, people in that public park can record anyone they want. There's no expectation of privacy in a public park.
Thank you. And thank you, Representative Roy, for summarizing the testimony. Representative Spillane.
Thank you, Mr. Chair. One of the other areas that they talked about that sort of had blurred lines was the expectation of privacy. And it pained me to hear the testimony of the young child who got some of his school years taken away by recording something at school, or recording the police interaction and then getting penalized at school and having his homework locked down and everything because there was no reasonable expectation of privacy for police arresting someone on the street. But again, I think that we've gone beyond the police situation, and I would point out as well that it was the Supreme Court case in 2014 of Frazier versus Evans that codified the recording of the police. We've gone beyond police here, though.
At this time, we will now move the question. If you are in support of the motion of inexpedient to legislate, please say yes. If you're opposed, please say no. Clerk will now call the roll.
Vice Chairman Roy.
Yes.
Representative Lang.
Yes.
Representative Burt.
No.
Representative Rhodes.
Yes.
Representative Green.
Yes.
Clerk votes yes. Representative Spillane.
Yes.
Representative True.
No.
Representative Pratt.
Yes.
Representative Marston.
No.
Representative Harriet Gathright.
Yes.
Representative Pantelakis.
Yes.
Representative Tulersky.
Yes.
Representative Bourdonnais.
Yes.
Representative Muse.
Yes.
Representative Ray Newman.
Yes.
Representative Bolden. Representative Conley.
Yes.
Representative Sue Newman,
Yes.
Representative Bradley,
Yes.
Chairman Abbas.
The chair votes yes.
17 yeas, 3 nays, 1 not voting.
There's one absent.
I got Brett, True.
You're right. And Representative Byrd as well. So by a vote of 17 yeas, 3 nays, and 1 not voting, the motion passes. Anyone wish to move for consent? With 3 you can.
I don't believe there's any sense in going on consent.
Will there be a minority report?
Yes?
And there'll be a majority report. Representative Brett. It will not be on consent. At this time, we will now close the executive session on House Bill 1175. At this time, we are now going to open the executive session on House Bill 1282 relative to the records of communication common carriers. Before I recognize anyone to make any type of motion, as I was saying, before I recognize anyone to make a motion. Representative Harry Gathwood, that was the complete opposite of what I was.
All she did was miss the word before. She missed before.
But knowing my friend from Nashua would never disrupt anything like that on purpose. But before we get to that, there was a bill we had last year. I believe it was HB 569. I supported the bill in this room. I spoke on, we're in the sports arena. I spoke at the sports arena in support of the motion of ought to pass. It passed in the House, went to the other body that we shall not mention, where it was ITL, or whatever version they have of that. It's our understanding, and Representative Roy inquired with the clerk, not the clerk for the House, the clerk in the body that we shall not mention, that are they allowed to hear this in the first place, or actually take this issue up? And my understanding of that conversation, the answer is no. Similar to where if we in the House were to find something inexpedient to legislate, if the same bill or a similar one like that were to come back, even if we change our mind and like it, I'm not sure we're allowed to act on it. So, with that being said, as much as I may want to show some support for the bill that was filed, 1282.
If I might ask the chair a question.
You're so recognized.
Has the Senate clerk read the bill to determine if it's substantially different or not, since it has not been yet introduced into the Senate?
Representative Roy, you may be the better person to answer that.
I gave the Voldemort clerk the bill numbers, but I did not actually give her the language. But she gave me a copy of the rule, and it clearly said that it's similar to ours. If it's ITL, that's ITL. They can't come back.
You may respond.
Thank you, Mr. Chair. Well, I had this conversation with the prime sponsor, the representative from Fremont, and his words to me were that the bill had been substantially changed and addressed some of the confusion that it created in the other body. And to that end, I think we ought to give this bill a chance. And OLS should have caught that and shouldn't have allowed it to proceed if that was the case, that it was that much, if it was that similar. So I'm of the opinion to let's pass this out of committee, send it over to the other body, and let the decision be made at that point.
And let me just clarify, to the determination of whether a bill is substantially similar or not is not something, as the chair, I'm allowed to make that determination. So I don't make that determination. It's just something to keep in mind. But if the clerk made that suggestion, and it may be an idea where it's going, it doesn't, and again, that's nothing to do with the policy of the bill. It's just something to keep in mind.
If I may, it's my understanding that in our body, the Speaker of the House determines whether or not something is germane or not the clerk of the court. That being said, the clerk of the other body doesn't have that role. That would be the Senate President, would it not?
Without being an expert on the rules, but if it's parallel to that of the House, correct.
Thank you.
But
May I read the rule out loud? It's short.
yes.
General Rules on Bills 3-21. Prohibition in second-year session. No bill or resolution, the subject matter of which has been indefinitely postponed or made inexpedient to legislate in the other place in the first year session shall be admitted into the second year session, whether as a bill, an amendment, a committee of conference report, or in any other manner.
Question, Mr. Chair?
Representative Marson, you've been recognized.
The question that I have is that I'm confused about what you're saying. This bill was previously passed in our House and went to the other body? No. Well, which is it? Yes and no is what I'm hearing. That clears it right up.
Yes, it was.
HB 5, is it, I have to go, I believe it's 539. So HB 539 was the bill we had last year. The language is not word for word the same exact draft. So, can I finish answering the question that I'm in the middle of before I take another one? So it's not the same word for word, but it doesn't, what I think a plain reading of the rule is that if it's on the same topic, subject matter, which this involves how the state government gets records from common carriers by getting a warrant. The last HB 539 was that same issue. How does the Attorney General of the state get records from communication, common carriers, and what that would have done, 539 would have increased it to a probable cause standard as opposed to reasonable suspicion. And my support for that was, well, what if the communication common carrier didn't want to provide the information? Some of these companies pride themselves on protecting our information, not just freely handing it over to the government when it's asked for. So I thought there was nothing wrong with a probable cause standard. But what this is doing, it doesn't say probable cause, but it's the same thing. It's making it, you get a valid search warrant before the records could be turned over, which is a probable cause standard to get a search warrant. So I'm just saying that to me, it's the same subject matter. Now, again, we don't make that. Representative Wallace is correct. That's for the president of the body we shall not speak of to make. I really don't like that rule that we can't just say what's going on with the title. But anyway, I think it's the same exact thing. It covers the same subject matter. It even has the same purpose. It's just written it's written differently, but it's the same thing.
Mr. Chair, I heard that there was it was a question of the chair. I heard a motion on this bill, but I did not hear a second.
No one was recognized for a motion. Not to put salt in the wound with Representative.
If there is no motion on the floor, then what are we discussing?
I was just discussing that issue before I recognize someone for, I just wanted to know,
Thank you.
and then it turned into a very in-depth discussion that I, Representative Harry Gathright. Do you wish to be recognized for a motion?
I'd like to make a motion to ITL this bill. Thank you.
Second.
That has been seconded by Representative Pantelakis. Representative Chu, you're recognized for your point of order.
I believe it is customary in this to announce the bill that we're getting ready to vote on, and I have not heard any announcement of whatever bill I'm supposed to be talking about.
Thank you for your point of order.
I heard a motion to this bill.
Well, are you saying that the way the representative, because they didn't say the bill number?
I guess what I'm saying is, if the motion is to ITL this bill, that is an improper motion. You can't make a motion to ITL this bill. What bill?
Well, we are in the middle of an executive session for House Bill 1282. So I'm not sure what the representative said. If the representative did say this bill during an executive session on HB 1282, I would assume they're referring to HB 1282.
I didn't even hear that we called an executive session on 1282.
We are.
I did not hear that called.
I understand. Representative Pantelakis?
I was just, excuse me, Representative Roy, did you understand the Senate rule to say that they would not accept it?
The Senate did not tell me they would not accept it. They sent me a copy of the rule after I sent them the bill numbers. And I understand the bill number to be that this is the same exact wording of the rule, subject matter. Regardless of how we tweaked it, it's the same subject matter. They wouldn't be able to take it up. But having said that, this body is free to make whatever recommendation it wishes.
Thank you.
That doesn't necessarily, and just because they won't accept it doesn't mean it should necessarily affect what you're going to do. Just throwing it out there to people. Representative Burt.
Thank you, Mr. Chairman. In the 12 years I've been here, we have never ITL'd a bill because the other body may not bring it up. Because the only person that I know of, as you pointed out, that can say, yes, this language is the same, is the Speaker of the House. Huh? Or the Senate President. So it just disturbs me that we are acting on a rule from the Senate. So with that said, I like the bill. I'm going to support it because, as they said, between 2018, the AG guy, 2018 to 2021, 41 to 43 requests were used under this program to get information, even minimal information, without a warrant. And he wouldn't answer the question, which I think was asked a couple times, how long does it take? Well, he would tell you how long it takes to get this under this program, the 41 to 43 times, if that's an accurate number, of how quick that is. But he never answered how quick he could do a warrant. And I wanted to know that because that is the way it should be. We must have warrants, and 60% of it, he says, is for, children, against, crimes against children. So, you know, yes, we need to hurry up and find out that information, if that's the case, but there's still laws that we should follow. And if this is a loophole or whatever it is that they use, or maybe it's a law that they use, this program that they talk, that number, you know, we got to have warrants for all of this. And again, you know, it just disturbs me that we are acting on what the other body is going to do or their rules when the speaker should be determining if this is different. Because bottom line, it's not different. I looked up the
Representative, can you
old.
suspend for a minute?
Yep.
You are recognized for your point of order. Please state your point of order.
Mr. Chair, usually before we start debate with other members, we offer the person who offered the motion the opportunity to speak. And I have not heard that person speak yet.
I can wait. No, I can start over later.
So I'm not clear the rules actually say, but I apologize. I think when the representative made the motion, there was a point of order, and I may not have gone back to the representative, and I apologize for that. But if it's all possible, suppose that is a rule that I did not follow, would the representative from Goffstown be permitted to please finish his dialogue before Representative Harry Gathright can speak? But you may be actually correct. I didn't mean any disrespect, but I just would prefer him to please finish his sentence. Do you withdraw the point of order?
I will withdraw the point of order.
Thank you.
All right. The reality of it is I don't even have to say anything, but I'm going to say something since you brought that to the attention of everyone.
Sorry, what?
I thought he was finished. I'm sorry.
No. Thank you. So I think my last thoughts were, you know, the speaker needs to make the determination, because when I look back at House Bill 539, yes, the intent is the same, but the words are different. Because what I look at is we ITL a lot of marijuana bills. Then we pass some marijuana bills. The intent is the same. It's to legalize marijuana. But the language is a little different. So that's why I am looking at this going, no, I'm going to go against the ITL and support another motion if that gets to that point. And, you know, because we do this all the time. We vote bills down of the same topic and support other bills of the same topic. That's why I want the speaker to see this bill to determine if it's germane or not. Thank you.
And just to clarify, whether this is similar subject matter would be for not even for the House to decide, it would be the others, so. Representative Harry Gathright.
I'll say it again. I'm making a motion to ITL HB 1282. I listened to this testimony of Benjamin Giddy, I think his name was, from the Department of Justice. And when he talked about most of these crimes were 60 to 70% of internet crimes against children, which is a big pet peeve of mine. And certain things have to happen almost immediately. I have to respect that, because anything that you do against children, in my opinion, we need to act on immediately. But he also said that we also have these laws already in terms of warrants. And he talked about two different type of warrants, not quite that I really understood them, but one was administrative and the other one was more on a search type basis. But he said that they had to get, I think one was through Superior Court and the other warrant was through the Assistant Attorney General. So these things are really already in place. So with that said, right now, I don't believe that this bill is ready for prime time. And I've also heard and know about the bill from last term 539. So with that said, again, I wish to ITL this bill.
Representative Newman.
I just want to say that I agree with the explanation that was just given. They have these administrative subpoenas, I believe is what they call them, and then they have the search warrant. They have the option of either or. And I believe the timeliness thing is a factor, and therefore, I don't really care what body did something to what other body with this bill. I'm just talking about what the substance of the bill is, and I think they should have both options. Thank you.
Representative Muse?
I actually wrote the minority report and voted against this bill the last time, and one of the main reasons I did that was because the only person who came and testified in support of it was the sponsor. And I really did want to hear from someone in the Attorney General's office what the implications would be of passing this bill. And, you know, the bottom line is it just doesn't seem to do much. You know, it would create, it would essentially force the Attorney General's office to go through some additional process work. But one of the things that we're talking about here is, you know, with an administrative warrant, what they're after initially isn't, you know, and he said this, he says, we're not after personal information, we're not after your, you know, the internet sites you visited. Those are all things that we have to get a search warrant to find. But basically what they are is they're trying to match an IP address that they have, you know, on internet child porn with IP addresses that the carrier would have. And if once you get a match, then what he was saying is we go for the search warrant. So to me, it seems like the administrative procedure that they have right now is proper. It allows them to get the information they need pretty quickly, and then if it's going to go any farther, they need to get a warrant for it. So I'm a little stuck on why we would need the bill, which is why I'm going to vote against it.
Representative True?
Thank you, Mr. Chair, and thank you for taking, we passed a similar bill last year. Now, this committee is not bound by what this committee did last year. I realize that. However, in reading the corrections or the changes from the bill that we thought was okay last year, this bill now becomes an even better okay bill this year. What this bill, the way I read it, is telling the Attorney General office that we have a constitutional right to our privacy. And if they want to start poking their nose into our privacy, they must have a search warrant. Not an administrative form. They must have a search warrant. And if they can get that search warrant, then my privacy is going to be looked into because they have probable cause. They have the search warrant. This is just a better bill that was a good bill last year. That said, all I know is the Speaker of the House decides and has already decided, because he sent this bill to our committee, he's already decided that this is a proper bill. And why wouldn't he? Because we passed it last year, or a similar bill last year. And therefore, we can pass a similar bill this year. What the Senate may or may not do has no bearing on how I will vote or a reason why I will vote for or against a bill. Did I say that word? I meant they who shall not be mentioned. Because I don't care what they might do tomorrow. Doesn't affect whether we've got a good bill today. Thank you, Mr. Chair.
Thank you. And I do agree with the constitutional side, because if the communication common carry does not want to comply with this administrative request, the Fourth Amendment says probable cause. So I don't understand what's going on here. I understand there's a public reason for. I'm not saying the witness from the Attorney General's office didn't make good points on what they're trying to accomplish, but the Fourth Amendment says probable cause. So if the communication common carry does not want to participate or voluntarily, cooperate with said investigation, I'm not sure why there's no probable cause standard there. I don't know. That was my speech on the, for the whole House. But it apparently didn't work very well in the body. Representative Spillane?
Thank you, Mr. Chair. I agree with Representative Muse on a lot of his discussion of where this goes. The administrative warrant, from my understanding and from what he said, only allows them to get, did they access this and what IP address was linked to it? Then they got to go get the regular warrant. So I don't see where passing this bill causes a problem. Because if they get the warrant in the first place, they get all the information. And they don't have to deal with the administrative warrant or administrative subpoena request. And it protects the Fourth Amendment rights and it protects our constitutional rights to privacy of data.
So unless someone has not had an opportunity to speak, do they wish to speak? Otherwise, I think at this point we're going to move the question. We're about to move the question.
Yeah, I understand that. So the question before us is an ITL. However, if we don't ITL and we choose to OTP it, it could go, either the speaker could rule it as a void, or it could go to the Senate, and the Senate would rule it
The
as
one
void.
regret I have is bringing up any kind of complicated
I'm
rule
trying to
procedures
understand
outside the purview of the committee.
Well, I'm
So
trying to
just
understand
forget-
what we're doing, what the implications are.
In the issue, it wouldn't even be in the House. It would be what happened if it passes the House. Would they be able to act on it? Representative True is correct that that has no bearing on this committee whatsoever. The policy is really what we should be deciding. So although I believe that anyone who reads this is going to find that the material is substantially similar and therefore make that said ruling, I am not the one that makes that ruling. I have no influence over that person to make the ruling. And with that being said, I think the point was being made, should that influence how we vote in here today? And I think we're about to find out if I can move the question. So at this time, the matter will now be put to question. If you support the motion of any expedient to legislate, please say yes. If you oppose, please say no.
Vice Chairman Roy.
No.
Representative Lang.
No.
Representative Burt.
No.
Representative Rhodes.
No.
Representative Green.
No.
Clerk votes no. Representative Spillane.
No.
Representative True.
Nay.
Representative Pratt.
No.
Representative Marston.
Nay.
Representative Harriet Gathright.
Yes.
Representative Pantelakis.
Yes.
Representative Tolerski.
Yes.
Representative Bourdonnais.
No.
Representative Muse.
Yes.
Representative Ray Newman.
No.
Representative Bolden. Representative Conley.
No.
Representative Sue Newman. Representative Bradley.
No.
Chairman Abbas.
The chair votes no.
15 nays, 5 yeas, 1 not voting. Motion fails.
After that, the chair will now recognize Representative Roy to make a motion.
I would like to move on to pass.
Second.
It's been seconded by Representative Wallace. And just so I don't make that same mistake again, Representative Roy, do you wish to speak to your motion?
No.
Okay, stop.
This time, the matter will now be put to question. If you're in support of the motion of ought to pass, House Bill 1282, please say yes. If you are opposed, please say no. Clerk will now call the roll. While you're getting caught up, I apologize for creating some confusion with the rules.
Okay, on the motion of OTP on House Bill 1282, Vice Chairman Roy,
Yes.
Representative Lang,
Yes.
Representative Burt,
Yes.
Representative Rhodes,
Yes.
Representative Green,
Yes.
Clerk votes yes. Representative Spillane,
Yes.
Representative True,
Yay.
Representative Pratt,
Yes.
Representative Marston,
Yay.
Representative Harriet Gathright, Representative Pantelakis,
No.
Representative Tulersky,
No.
Representative Bourdonnais,
Yes.
Representative Muse,
No.
Representative Ray Newman,
No.
Representative Bolden, Representative Conley,
Yes.
Representative Sue Newman,
No.
Representative Bradley,
Yes.
Chairman Abbas.
The chair votes yes.
14 yeas, 6 nay, 1 not voting.
Motion passes. On a positive note, you can probably use the majority report from last year and recycle that. And Representative Musa, you wrote a minority report on a similar bill last year, so I assume you can recycle that as well. So would you be preparing the?
Not quite, but I'll figure out a different angle on it this time.
At this time, we'll now close the executive session on House Bill 1282. We're not going to exec anything else today, but just so some members can get a head start, there is a prepared amendment on HB 1108 and 1433. So I would just make sure everyone has a copy of that before they go.
Should be making its way around.
1108 is right here.
We will take these up next.
And this time, the Criminal Justice Public Safety Committee will be adjourned.
Is 1108 coming this way? Is that it?